Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1177 et al. Center for Biological Diversity Petitioner versus Environmental Protection Agency et al.
Morning.
Good morning. May it please the court, Elizabeth Dawson presenting today on behalf of obligated party petitioners regarding the majority of the issues briefed, after which my co-counsel Jonathan Harden will address the small refinery specific issues, including the Regulatory Flexibility Act. I'd like to reserve 3 minutes of time for rebuttal. The 2023 to 2025 renewable fuel standard is unlawful. This court's prompt remand is critical because as of today, November 1st, 2024, EPA is once again violating its statutory duty to promulgate renewable fuel volumes, this time for 2026, which the Clean Air Act requires no later than 14 months before the first year for which such applicable volumes will apply. EPA hasn't even proposed applicable volumes for 2026. The only silver lining in this situation is that this court could still issue an opinion that influences how EPA approaches RFS rulemakings for 2026 and beyond. This court should seize this opportunity for 3 overarching reasons. First, timing. It's past time for EPA to be held accountable for its inability to get back on track with RFS rulemakings. EPA has abused this court's leniency and has replaced the plain language of the lead time requirement with a reasonable mitigation requirement. And for 2023 and 2024, EPA complied with neither. Second, policy. The set provision espouses no policy in favor of annually increasing volumes, but EPA unlawfully superimposed such a policy onto the set factors analysis, biasing the results in favor of higher volumes for 2023, 2024, and 2025. Third, implementation. Instead of looking to Congress's non-aspirational factors evaluating the impact of renewable fuel use and a clear-eyed review of the program's performance, EPA forged ahead as though the congressional defaults still applied, resulting in arbitrary, unprecedented levels of required renewable fuel and an unlawfully predetermined supplemental standard. For all of these reasons, the court should remand the set rule.
So is your challenge to the implied conventional fuel volume and the advanced non-cellulosic biofuel volume that EPA didn't analyze the factors, the statutory factors, or that it's going to increase compliance costs, or both?
Both, Your Honor. I mean, and they're intertwined because cost is a factor with regard to the set factors. So in the set rule, EPA intentionally implied this unreachably high conventional biofuel requirement on purpose with the thought that it could somehow compel the production or increase production of E15 and E85, even though several places in the record, EPA concedes that it isn't clear whether that has actually worked in practice, at JA 1806, 07, and JA 1810. EPA says it's unclear to what extent these volumes will materialize.
And then their response to that is, well, the advanced biofuel will backfill. And then you make an argument that forcing advanced biofuel to backfill the conventional renewable fuel mandate will cause RIN prices to, quote, converge with ethanol RINs rising to meet the price of advanced biofuel RINs. And I wasn't sure that it was clear to me why you thought that would happen as opposed to converging down, and whether you can point to any evidence or anything in the record to support that phenomenon.
Yes, Your Honor. EPA actually acknowledges in the response to comments that the price will increase for conventional biofuel, because what happens is when advanced biofuel is necessary to fill the conventional biofuel requirement, it causes both prices to go up because there is more demand overall for conventional, so it can charge more for its RINs. And EPA does.
If there's more demand for conventional, even without the separate backfill, the price is going to rise. But I thought you were talking about some relationship between, is it the D6 price and the price? And it just wasn't clear to me why, even if you didn't have the advanced biofuel backfill, the point of the program is the price will rise and that's part of incentivizing the production.
Correct, Your Honor, but if the conventional biofuel the total renewable fuel volume had been lower, then there would have been less demand for that fuel. Whereas by increasing it artificially, it increases the cost overall.
On its own, but the point I'm not following is the convergence point. And maybe it's not as major as I'm reading it to be in your brief.
No, Your Honor, I mean, that is correct, but I think both, EPA acknowledges that and doesn't contest that there is this convergence in the record. And so one of the other points with this is that it doesn't increase the renewable fuel volumes overall, which is EPA's stated purpose, even though that we disagree that at this set posture, that is a lawful way for EPA to approach the program. Even if that were lawful, doing this doesn't achieve EPA's stated result. I'd like also to talk really quickly. Oh, I'm sorry. You're on. Okay.
Well, I was going to move to the Sinclair case because you
Yes,
had that happen in May of this year,
Mhm.
and we already have a majority upholding the 2020 to 2022 renewable fuel. And you have the same analysis having been done in the Sinclair case as you do in CBD. In fact, the record for the Sinclair JA site is JA 151. And then here for CBD is JA 1308. And the tables for ES1 look almost identical in terms of, the analysis that was done. You have the set factors. In those factors, it says and. It does not suggest that you have to give greater weight to one factor or the other. And so you keep referring to higher costs. And we understand that, costs are higher. But it didn't state that you have to focus more heavily on the cost in that regard. So why isn't Sinclair the precedent that we should go by in terms of this qualitative analysis?
Well, Your Honor, we acknowledge that earlier this year, this court did uphold the EPA's decision for 2020 to 2022 on the reset analysis. But we submit that this is an entirely different era of the program. We are now in a set posture where, as in Sinclair, EPA was resetting the volumes that Congress had already set based on those set factors. Here, EPA has to look at what should be the volumes going forward, separate and apart from anything Congress already did, because there are no tables here. While the factors remain the same, EPA had to look at the entire body of the program prior to this time, look at how it was implemented, look at those factors and the additional provisions that are specific to cellulosic and advanced and biomass-based diesel, and come to a reasonable conclusion, divorced from the prior policy that Congress had to increase volumes.
I mean, that's true, but the reset authority at issue in St. Clair pointed at the same 6 factors.
Yes, Your Honor, but we do believe that it's different in the sense that EPA was looking at the program at the time that Congress had set default volumes, whereas there are no default volumes here. This is a new phase where EPA is supposed to be going forward, looking more at a retrospective review and at what is reasonable in reality, not aspirational factors that Congress clearly embodied in those statutory tables.
On the RIN cost pass-through theory, I'm not entirely following your argument that it harms the non-small refiners that you represent, because if EPA abandoned the RIN cost pass-through theory, wouldn't that lead to an increase in the percentage standard? It would lead to more small refiner exemptions and an increase in the percentage standard imposed on your non-small clients, because more exemptions would be granted to the small refiners, and so more of the total volume would have to be met by non-small.
Well, Your Honor, my colleague, Mr. Hardin, is going to be handling pass-through in more detail, but as to the non-small refiners, the point is not the percentage standards necessarily themselves. We acknowledge that if EPA applies the reallocation framework that it had said earlier it would, notably it hasn't because it projected no small refinery exemptions. But if that happened, the percentage standard would increase. But that doesn't mean that the total volume set would necessarily increase. And the argument is that, in fact, it should be lower if you consider the implications of the pass-through theory on the, or the failure of the pass-through theory on the program.
Upfront.
Correct. I know I'm out of time. I would just like to briefly touch on timing if I could. past time for EPA to be held accountable for its failure, really, to promulgate volumes on time. Here we are in now a posture where the deadline is actually supposed to be even earlier, 14 months before the first year to which it should apply. And EPA's continued reliance on extended compliance deadlines as mitigation must be rejected. Compliance deadlines are paper exercises. It's the compliance year that is important because obligated parties can't demonstrate compliance no matter what deadline it is in the future when EPA promulgates rules that are too late for the market to catch up. And so without further questions, I would reserve the remainder of my time for rebuttal.
Thank you, Ms. Dahl.
Thank you.
Now we'll hear from Mr. Hardin.
Thank you, Your Honor. May it please the court, Jonathan Hardin representing the small refinery petitioners. I'd like to reserve 1 minute for rebuttal. I'll briefly address two ways that EPA's reliance on an economic theory called RIN pass-through renders the rule arbitrary, capricious, and contrary to law. First, EPA relied on its RIN pass-through theory to ignore the cost of RFS compliance to obligated parties in violation of the Clean Air Act and the EPA. Second, EPA relied exclusively on its pass-through theory to refuse even to perform the flexibility analysis required under the Regulatory Flexibility Act.
On that latter, just before you get into the merits, I didn't see cited in any of the comments the Regulatory Flexibility Act. And so there is a question raised as to whether that challenge is preserved at all.
Yes, thank you, Judge Pillard. EPA was unquestionably on notice that from commenters that its RIN pass-through theory was hopelessly flawed, and EPA stubbornly relied on that theory at its own peril to promulgate the rule. And that was the exclusive reason that it refused at the screening phase to refuse to perform the flexibility analysis. So the idea that EPA was not on notice that its RIN pass-through theory was being challenged and its reliance on that for the Regulatory Flexibility Act is not a waiver. And that would respectfully, that engage in the kind of hair-splitting analysis that the Supreme Court just rejected earlier this year in Ohio.
You think it's hair-splitting when they don't? They said this theory is problematic and therefore you should do two things. You should lower the volume requirements under the Clean Air Act and you should grant more small refinery exemptions under the Clean Air Act. You think it's hair splitting to say that those arguments don't encompass a different statute that was never mentioned?
So I do think it's hair splitting for EPA to say that we couldn't have known that our reliance on RIN pass-through to refuse to perform the regulatory flexibility analysis had not been challenged by the commenters.
Well, the regulatory flexibility analysis, for example, and the small refinery exemption, those are two different standards. And I mean, I just don't see, you're right that the RIN pass-through theory was raised, but for example, in Sinclair, Wyoming, and in Calumet, the courts that were considering RIN pass-through, both those courts accepted that pass-through occurs on average and in general. They were just looking at, specific individual small refiners and particular periods. I'm not sure how that bears.
Yeah, so I would dispute, Judge Pillard, that those courts accepted that RIN pass-through occurred on average across markets as a whole. I think it's more accurate to say that that type of macro analysis in those cases, which were specific applications to small refineries, was not necessary for the court to pass on the validity or invalidity of RIN pass-through theory at a macro level in order to decide those cases. But to be clear, EPA's RIN pass-through theory is wrong, not just as applied to small refineries, but its pass-through theory is that all obligated parties, regardless of size, regardless of the markets that they participate in or their share of that markets, or any other characteristic, that all obligated parties have no cost of RFS compliance whatsoever, zero. When you say it out loud, it already sounds too good to be true. And that's because it's not true. And here in the record, you have the GAO analysis, which found that EPA's assumptions that all parties pay the same cost for RINs
So do we
at all
have to-
times is incorrect.
So we have to decide this in this case, this sort of in average on general RIN pass-through, the validity of the RIN pass-through theory.
Yes, because EPA relied on it in several ways. It relied on it in its analysis of the statutory factors on cost. That's at JA 38. It relied on it in its regulatory impact analysis in Chapter 1, where it claimed to be performing the review of the implementation of the program that it's supposed to base the volumes on. And nowhere in that regulatory impact analysis about the review of the implementation of the program does EPA take into consideration the real world cost to obligated parties.
But in order to use the RIN pass-through problem as a basis for lowering or setting aside the volume requirements, we would have to conclude that the theory is sort of rotten at its core, not just inapplicable to a couple of small refiners here and there, right?
Yeah, so I think there is the basis in this record to show that at least a remand to the agency to consider the volumes and its Regulatory Flexibility Act analysis without relying on the pass-through theory is warranted.
I mean, it seemed like the GAO study, the other Sinclair opinion from our court, the Fifth Circuit opinion, all questioned the theory as applied to small refiners. They didn't say as a general matter it was wrong.
Yeah, so I would say, well, first of all, for the Regulatory Flexibility Act analysis, we're only talking about small
Fair
entities. So that I think even if you were to credit Judge Pillard's question, which I disagreed with earlier.
RFA, you're
it's not
stronger
small.
on the merits. You
Right.
have a preservation issue.
Right.
On the volumes themselves.
Yeah, but on the volumes themselves, with respect to all obligated parties, the GAO found that the assumption that all parties, not just small refineries, but that all parties pay the same cost for RINs all the time, in all markets, on all days, and that all obligated parties fully pass through their costs all the time. It's a net zero program. It's a utopian view of the world. GAO found that assumption was flawed and incorrect, and it found that it was an incomplete assessment because it only relied upon a few large markets.
But the
That's a systemic problem.
The GAO study has been systemically criticized by EPA and has chosen not to rely on it because of really major errors such as valuing very small transactions, the price paid, the same as very large transactions. So you end up with just enormous distortions in the GAO study. And I don't see anything in the record that repairs that. And EPA has a tremendous amount of data that it has analyzed, and it has come up with, you said, we can't say that on each day for each party, the price is always fully passed through. But that's not I don't take that to be the contention that EPA is making when it's setting annual volumes. It's saying on average and in general. So some days you're going to get, a cheaper RIN than, and other days you're going to get more expensive, but it's on average and in general, the cost is going to be passed through.
Yeah. So
What do you point to in the record that we really need to grapple with, other than the GAO study, that undermines that conclusion?
So first of all, I would point to how EPA uses its pass-through analysis, because it exclusively relies on what it calls the most recent analysis that it did, which was the denial actions. And every time it relies on its pass-through theory, it cites the denial actions. And it's an assumption, not that there is, some evening out over the macro analysis. Their assumption on which they base the volumes and on which they refuse to perform the regulatory flexibility analysis is that there is zero pass-through, that every obligated party pays the same price, 100% pass-through, right? And so I think that EPA uses it heavily as a magic wand, waving it around to pretend that there are no cost obligated parties, and that warrants a remand for EPA to consider the real world costs to obligated parties of RFS compliance. Thank you.
And I have next that we'll hear from Ms. Apfel. Morning.
Good morning. May it please the court. Carrie Apfel for petitioner National Wildlife Federation. I'd like to reserve 1 minute for rebuttal. We are here today presenting a classic case of arbitrary, capricious, and unreasoned decision-making. In this instance, it relates to a market-driving program that is propping up the continued production of corn and soy for biofuel use beyond what the market would otherwise dictate, absent the program's mandates. And this is causing significant harm to the climate, the environment, and to environmental justice. While the briefs may raise some confusion, what EPA did in this case is actually quite clear. Simply put, it unreasonably assessed the climate and environmental harms of the renewable fuel volumes and thus failed to demonstrate a reasonable connection between the facts on the record and the resulting policy change, which is the standard this court set out recently in Sinclair, Wyoming. EPA failed to meet its baseline APA obligations by unlawfully setting volumes for which it showed no record support, failing to consider an important aspect of the problem, and failing to provide a reasoned explanation. As we all recall from grade school math, if you don't show your work or explain your answer, you don't get credit. And that's what happened here. As we set forth in our briefs, EPA's analysis fails for 3 primary reasons. First, EPA improperly assesses the effect of the set rule on climate. It inadequately explained its unquestioning reliance on uncertain and unaligned estimates in the literature review. At the same time, it inexplicably ignored a significant climate impact, which is the opportunity cost of keeping land in agricultural production for corn and soy for biofuel and preventing that or other land from being used for other purposes. And it also disregarded its own model comparison exercise. Second, EPA improperly analyzed the grave environmental and justice impacts of the rule, including, for example, an increase in over 100,000 tons of air pollution attributable to the production of corn ethanol, characterizing these harms as minimal without sufficiently explaining why this is so. And third, given the fundamental flaws with EPA's analysis of the individual factors, EPA does not and cannot provide a reasoned explanation for the volumes. In fact, had EPA shown its work, there's no reason to think that the evidence in the record would support these same volumes. Notably, because we're challenging EPA's analysis of the individual factors rather than EPA's balancing of those factors, this court's recent holding in Sinclair, Wyoming does not control here. So with this backdrop, I'd like to focus my limited time on EPA's problematic climate analysis.
Sorry, can you just drill down a little bit on why you think Sinclair is not controlling?
Sure, Your Honor. In Sinclair, the court was looking at
On the Clean Air Act issues.
well, Your Honor, in Sinclair, what the court was looking at, my understanding, was the inclusion of a qualitative analysis. So EPA analyzed a variety of factors, but it only quantified a few select factors. Other factors, it gave a qualitative assessment of those factors, and then it balanced the qualitative and the quantitative collectively. Here, we're not saying that it can't include qualitative analyses. Here, we're saying its qualitative analysis, specifically on climate, was improper and inadequate, and therefore, it can't balance factors when those factors were inappropriately assessed.
And your basis for that is that EPA's decision not to include a carbon opportunity cost analysis into its climate analysis as unreasonable. But there has to be an assumption when one is doing a climate opportunity cost analysis, right? And your assumption seems to be you can correct me if I'm wrong, that in the absence that farmers could convert existing cropland to forest, and they could do that, but we're in a situation where EPA doesn't actually have any control over what happens to land use. So wouldn't EPA instead need to consider what the likely real-world alternative uses would be of land in the absence of the RFS standard, not ideal ones that would really be more pro-climate?
Right. I understand the question, Your Honor, and I have a few answers. To the first part, there are a few reasons that we think the climate analysis was flawed. One of them is the carbon opportunity cost, which I'll get to, but there's also two other reasons, which is the literature review itself is fundamentally flawed for reasons which I can describe in a moment. And then also its disregard of the model comparison exercise. The third reason is its failure to consider the significant climate impact from this carbon opportunity cost. And I think that thinking that farmers have to revert that land back to forest land or native grassland is a misconception of what this opportunity cost is. This cost recognizes that land is a finite resource. So if you're keeping land in production for corn and soy for biofuels, that particular land can't be used for other resources, such as growing food for human consumption or animal feed or sequestering and storing carbon.
If it were used to grow food for human consumption, the climate analysis might be the same.
Well, Your Honor, what happens because that land is not being used, there's land clearing elsewhere in the United States and globally, and those are factored in. In fact, EPA itself recognizes the global impact of the program. So what we're looking at is not just the specific parcel of land and how that's being used, but its effect on how other land is being used. And so there's a displacement. So rather than using that land to produce food for human consumption, other land has to be found to be used for that, and that has a climate impact. And EPA completely ignored that climate impact because it says that it's not a life cycle analysis.
In terms of the literature review and the model exercise, on the model exercise, I just read it differently, what EPA was doing there from how you read it. I don't think they were running the model exercise to come out with data for this rule. They basically, I mean, it's almost like, and here's something else that might be interesting that we're thinking about to develop and select models for future, and they want to comment on it. It's like crowdsourcing an idea, but I don't think they purport to rely on any of that for this rule.
Well, they don't, I'm sorry, Your Honor.
But they do rely on the literature review where they're basically saying, what's the best science available on the climate effects? We're going to look at what's published and what they find out there and use the data and then scale it to the project before EPA. What they find out is that there's a very wide range. And I mean, that alone seems problematic, but I don't take that to be what you're challenging.
Your Honor, we're challenging both these things. We are challenging that aspect of the literature review and the fact that in its entire 465-page regulatory impact analysis, EPA itself never comes up with an independent conclusion about the climate effects of the rule. Instead, it looks at these studies, it says, here's the range of results from these studies, and the closest it comes is to say that they tend to be lower than the emissions from petroleum. But it never analyzes the underlying data in the studies, their methodology, their relevance, their validity, the data itself. It would be like this court's looking at a range of GPAs for law clerk applicants without looking at the underlying data, like where they went to school and what their grades were and what classes they took. You need to look at the underlying data to get a sense of the validity of the studies that they looked at in the literature review.
But what value would we give the concurrences then?
I'm sorry, Your
What
Honor?
value would we give the concurrences with respect to how the 250-page biological evaluation that occurred here too, though?
Well, within the biological evaluation, they also recognize that there's these climate impacts. They talk about land conversion. They talk about a lot of the environmental and harms that come from conversion of land. Those have a climate impact as well. And they also ignore several studies that talk about the carbon opportunity costs. And they say that these are outlier studies. They say that in the brief. Sorry, counsel says that. EPA itself doesn't say that. But there's record evidence that talks about these studies at JA 531 to 533 that talk about the climate opportunity costs. And EPA itself recognizes this global impact in the record itself, But again, it excludes these studies because it says that they're not life cycle analyses. But the statute requires EPA to consider all climate impacts, not just those climate impacts that stem from life cycle analyses.
Although, wouldn't that be very distorted if, I mean, they need to come up with, that's the case I gather for these biofuels, is some kind of life cycle analysis. And if they, they have to have some theory about what the relevant unit of measure is, and they've chosen a life cycle.
Well, Your Honor, the statute requires them to consider life cycle analyses when looking at whether a particular fuel has a 20% reduction. And so to set which fuels qualify as renewable fuels, that requires a life cycle analysis. But the statute here says that they have to consider climate impacts. And yes, they can look at life cycle analyses, but it's unreasonable to ignore an important aspect of the problem, which is the tremendous climate impact that comes from keeping land in use for this type of
And in
production.
looking at an important aspect of the problem, they can give it little weight or great weight. And so do you have a consideration as to what emphasis they should place on either little or great?
Well, Your Honor, regardless of whether it should be little or great, they gave it no weight at all. They failed to consider it at all. And here with the literature that they did review, they also didn't explain what they gave any weight to. Again, they didn't reach any independent conclusion. They just said, here's the results from these studies. We're not looking at what their relevance is. And in fact, EPA itself says that the studies do not align in terms of their scope, system boundaries, time horizon, year of analysis, or other factors. And that's at JA 1435. And EPA also said that it did not, quote, adjudicate which particular studies, estimates, or assumptions are most appropriate. And that's at JA 33 in the preamble. So EPA itself is not telling us what weight it gave to any studies or how it's looking at any of these studies, as opposed to just blindly accepting the range of estimates that they provided. So, Your Honors, I see I'm out of time. We just respectfully request that this court finds that the rules arbitrary and capricious and a violation of the Clean Air Act and the APA. Thank you.
And I gather we'll hear next from Margaret Coulter.
Morning. May it please the court. Margaret Coulter for Petitioner, Center for Biological Diversity. I'd like to reserve 1 minute for rebuttal. The Endangered Species Act requires formal consultation for all agency actions that may affect endangered or threatened species or their formally designated critical habitats. Given the enormous scope and scale of this program and EPA's acknowledgments throughout the record that adverse impacts could occur, it is implausible and arbitrary that the EPA and the wildlife agencies found that the SAT rule was not likely to adversely affect any of hundreds of listed species or their critical habitat. This is arbitrary, capricious, and violates the ESA. And this failure matters because formal consultation is the only mechanism for requiring conservation measures to mitigate the potential harms that EPA acknowledged throughout the record. I'll start first with the Fish and Wildlife Service, whose conclusion is the most egregiously unlawful. Despite EPA's acknowledgments in the record that the SET rule may affect listed species and critical habitat, including a table of the top 10 species most impacted, all of which are within Fish and Wildlife Service's jurisdiction, Fish and Wildlife Service categorically found no effect for all species. But EPA acknowledges, for example, up to approximately 5% of the Salt Creek tiger beetle's critical habitat could be converted to cropland. And critical habitat is defined as habitat that the agency has found essential to the conservation of the species. But Fish and Wildlife did not undertake any scientific analysis of these potential impacts, and yet made a blanket determination that the SET rule would have no effect at all on these and other protected species and critical
How can we
habitat.
hold that blanket determination unlawful when it was based on the two-part causation test outlined in the regulatory definition of, quote, effects of action in 50 CFR 402.02?
Your Honor, I think you're referring to the reasonable certainty standard that Fish and Wildlife Service uses in their concurrence letter. So the statute and regulations don't require that this uncertainty be resolved as a threshold for moving into formal consultation. And formal consultation is where the agency should be utilizing the best available science to grapple with this uncertainty. So the plain language of the ESA and implementing regulations require formal consultation where action is likely to adversely affect species.
Am I right in putting weight in the assignment of the likeliness, the threshold likely to affect determination on the EPA as opposed to on the services?
So the EPA provides information to the services, and it's on the services to determine whether or not to concur. And so when Fish and Wildlife is looking, EPA makes this acknowledgement of many potential impacts that could occur. And Fish and Wildlife Service doesn't even grapple with any scientific analysis of its own with what EPA prepared. And this lies in contrast to what NIMS actually did here, which we think was inadequate, but NIMS at least completed an initial analysis of the impacts to species and habitat. And in fact, NIMS scientifically evaluated impacts to a species, Gulf sturgeon, a nearly identical species to that located in very close proximity to a Fish and Wildlife Service species, the pallid sturgeon. So when you compare the two approaches there, Fish and Wildlife Service failed to consider these impacts and grapple with the science, and that is arbitrary and capricious here.
Are they?
Look, there's a odd feature of the two regulations at issue, odd textual feature to me anyway, which is the substantive rule of formal consultation is keyed to actions that either may or are not likely to have an affect with an A. And there's a defined term of effect with an E, which Judge Pillard had just mentioned. Do you accept the proposition that the affect in the operative rule is just something that has an effect, which is a defined term?
I think that's how the services have interpreted.
That is how they have.
Yes, and I think that
Do you dispute that?
I don't think we do dispute that.
Because then, I mean, it just gets very odd. If you look at the operative rule, it seems to be somewhat favorable to you. May affect is a species-friendly standard. Not likely to adversely affect is, you know, maybe it's 51% if you drill down into what they say about discountable. It seems like it's a species-friendly standard. But you go back to the definition of effect, and it's just not an effect at all unless there is something, unless the harm is reasonably certain to occur.
So the
And that's a very, pro-action agency standards. I don't know how to reconcile those.
So if you look at the services handbook for ESA Section 7 consultation,
Have done that. Go ahead.
there's a section on concurrence for the wildlife agencies with not likely to adversely affect determinations, which quote says, if the nature of the effects cannot be determined, the benefit of the doubt is given to the species, do not concur in this instance. And that's in the joint appendix at 2134, handbook page 3-12. And so here where we're going from informal consultation to formal consultation, the nature of the effects, if they are unable to be determined, if there's uncertainty, that should be resolved in a formal consultation.
That makes perfect sense, but they have to be effects in the first place.
The may affect standard is many courts have found is a very low bar for entering into formal consultation. And here we would argue that Fish and Wildlife Service and EPA's acknowledgements throughout the record should push it into the formal consultation process.
So is it correct to think about the way that EPA and the National Marine Fisheries Service looked at the issue was with these two regulations that Judge Katsas points out, feel like they point different ways, is that EPA, National Marine Fisheries started with may affect and moved from there into the question of whether those effects are, it's likely to adversely affect, and then looking at insignificance and discountability, whereas Fish and Wildlife Service kind of started at the end and asked kind of implicitly, after we think about discountability and insignificance, is there an effect of the action that is reasonably certain to occur, and said no? And if so, what's wrong with those two different services coming to concurrences from two different avenues?
I think as you're thinking through the consultation process, what EPA did here was started with an informal consultation. And if you're looking at informal consultation, the standard is may affect, and that's a very low bar. And so the way that EPA and NIMS looked at the effects, whether they crossed that low bar to get into the next step of not likely to adversely affect potential determinations, that is the typical process that's outlined in the Section 7 handbook. And what Fish and Wildlife did here, like you said, is kind of going for it from the back end, saying if we're going to be trying to determine, the ESA's substantive standard that is ensuring against jeopardy, we need to look at, are there any reasonably certain effects? And that's coming at it from the back end. And in the order of those operations is reversed here. And here we're in this situation where we're in informal consultation, and we're needing to step to formal consultation because of the numerous potential effects that EPA outlines in the biological opinion.
Maybe it'll help if you talk about how National Marine Fisheries Service erred, because if National Marine Fisheries Service did not err in its occurrence, it is hard to see how this starting at the back end by Fish and Wildlife was problematic. But if National Marine Fisheries Service did err, I see your point that it seems like maybe Fish and Wildlife Service jumped over an important analytic step, and that's the results of that would have pointed toward formal consultation.
Sure.
So I guess can you further explain why you think EPA failed to analyze harms from water pollution? It seems like EPA did evaluate the potential for water pollution and determined that any such effects were insignificant or discountable. And then I took you in your reply brief to say, well, NMFS's conclusion as to discountable effects was reasonable, but its conclusion as to insignificant effects was arbitrary. Am I right about that?
Your Honor, yes, I think that we would say that there's a spectrum of effects to species here, and it may be the case that some of these effects could potentially be discountable. So here we have the example of how NIMS looked at water pollution. It found not likely to adversely affect, as you said, citing insignificant and discountable, so finding that some of these effects are insignificant and discountable. So for example, it justified its determination by setting an arbitrary 1% threshold for changes in pollutant concentrations from crop conversion, calling anything less than 1% insignificant indiscriminately for all salmon and sturgeon species. These are the species most affected by water pollution. But there's nothing in the ESA that excuses harms merely because they're small or because they're below some 1% threshold. And NIMS provides no discussion of why a 1% threshold could be appropriate for any specific species or any specific designated habitat. So this is unlawfully arbitrary. And so when we're looking at discountable, we agree it's likely that there may be some effects to species that are discountable, such as for whales and manta rays. But this is not the same as effects that may be incrementally small, such as less than 1% changes to pollution concentrations, which NIMS claims are insignificant.
So as I read it, EPA didn't just say 1% per se is insignificant. It said that it would not be measurable. Which seems to me to track the applicable standard pretty accurately. the inherent variability of exposure can vary over 10% due to differences in factors such as precipitation and soil type. And when it says it's not measurable, it's hard for me to see how that isn't a legally valid determination of insignificance.
So the services handbook has this long-standing definition of insignificant, and I'll quote from the handbook. It's at Joint Appendix 2126. Insignificant is not, sorry, here's the quote. Should never reach the scale where take occurs, and take, even if unintentional or not lethal, is expected to occur to even just one individual of any species, or any adversely modify any critical habitat. Concurrence is not appropriate.
Maine lobsterman roundly rejects that.
Maine lobsterman dealt with a factually different situation where we were in the formal consultation process and we were dealing with the jeopardy question. Here we're getting from, we are looking at the very low likely to adversely affect standard. And here we're seeing the agencies using uncertainty to avoid consultation. And so there the court found that in the case of uncertainty, an agency can't just throw up its hands and rely only on a presumption there of the worst case scenario to avoid using the best available science. And so NIMS fails to engage with this extensive existing scientific data surrounding hypoxic dead zones in the Chesapeake Bay and Gulf of Mexico. And as we heard in Maine lobsterman, this court found the core of the service's remit is to form a scientific judgment. And so we've seen that Fish and Wildlife Service didn't grapple with this science at all. And EPA acknowledges, oh yes, there is a hypoxic dead zone. Oh yes, it is continually adversely affected by additional pollution from sediment, runoff, from fertilizer, from pesticides, from the kinds of activities that this rule is action forcing.
So even the handbook itself, which you refer to in your, and you distinguish Maine lobsterman by saying that was in a formal consultation, which I appreciate. But EPA itself references the consultation handbook definition of insignificant effect as those that a person would not, quote, be able to meaningfully measure, detect, or evaluate. And I think it's speaking to that by saying these water quality effects are not detectable. And your response to that, I know you've just given me, but succinctly your response to that is?
When you look at a watershed, all pollution flows downstream and aggregates. And we know where critical habitat is. And for species that live in water, we know what those watersheds are. And so as you think about effects, measurable effects to species, the aggregation of ordinary water pollution affects these species. And so I think that if you think about what is insignificant as measurably detectable, you look at the effect to these species. And for example, in EPA's top 10 table, we've got at least 2 fish species, 2 crayfish species, and water pollution is cited as one of the reasons why those species were listed in the first place. So that adverse modification of their designated critical habitat meets that very low likely to adversely affect bar, pushing us into formal consultation.
So are you saying that the very figures on the table kind of belie their non-measurable
I think that's right.
conclusion?
Thank you. I see I'm out of time. If you'd like me to briefly conclude, or if I can reserve my 1 minute for rebuttal.
You can briefly conclude in 20 seconds and reserve your 1 minute.
You got it. Thank you. So at its core, it's implausible that this enormous program is not likely to adversely affect even a single individual of any of hundreds of affected endangered and threatened species, nor adversely modify any critical habitat. So we respectfully request the court find the agencies violated the ESA and vacate and remand the corn and soy volumes in the rule.
Thank you.
Thank you.
We hear next from EPA Alexander Porpero. Porpero.
Yes. Good morning, Your Honors. May it please the court. My name is Alex Porpero, appearing on behalf of the respondents, along with John Martin with the Department of Justice. I'll be arguing for 22.5 minutes in response to the Clean Air Act and Regulatory Flexibility Act claims raised by environmental petitioners and obligated party petitioners. My co-counsel, Mr. Martin, will argue for 7.5 minutes in response to the Endangered Species Act claims raised by environmental petitioners. The court should deny the petitions for review. EPA acted within its statutory authority to assess the statutory set factors as well as the implementation of the program to set achievable renewable fuel volumes that appropriately account for the balance of the factors. EPA properly considered the timing of its rulemaking in setting those factors and properly set the supplemental standard in response to this court's remand MACE. Further, the Regulatory Flexibility Act argument asserted by petitioners has been waived, but even so, it's not a basis for overturning the rule. And finally, the agencies have properly complied with their obligations under the Endangered Species Act. EPA has applied the statutory criteria under Section 7545.02b2 to set renewable fuel volumes that advance Congress's policy of increasing renewable fuel. This court has repeatedly held that the purpose of the renewable fuel standard is to increase consumption of renewable fuels. There's nothing improper about EPA's analysis, where it has applied the statutory factors and considered the implementation of the program to set renewable fuel volumes progressing into future years. The EPA reasonably considered each of the factors.
Mr. Purpura, can you help us to understand EPA's decision to set the advanced biofuel volume around 1 billion gallons below the candidate volumes that the record suggested would be reasonable and appropriate to require based on the analysis of all the statutory factors?
Sure, Your Honor. So when EPA assessed the candidate volumes, it was assessing the types of fuel within each of those categories. And when it set the final volumes, it decided to maintain the statutory implied volume from the prior rulemaking, which includes the 15 billion gallons or 15.25 with the supplemental standard. And in doing so, EPA recognized that the total renewable fuel volume, so the amount outside the advanced standard, can be accounted for with both conventional fuel and advanced biofuel. So it still accounts for that portion of the advanced biofuel category, and that can be used to satisfy that gap in the implied volume.
I guess my question more pointedly is, how would the 15 billion gallon implied conventional fuel volume incentivize the production of E15 and E85? I take it EPA here is looking to incentivize a volume that will push past the blend wall. I take it the blend wall in the real world terms is reflected by the inadequacy of infrastructure, of vehicles that can accommodate more than E10, and that if there's a greater supply of ethanol and it's cheap enough, that will trigger the development of infrastructure of the vehicles that will hurdle the blend wall. And so that's sort of the policy idea behind, in part, the statute and behind EPA's position. Is that right?
Yes, Your Honor, that's correct.
And so then my question is, well, if the projection that EPA is making is that the extra billion or so of the implied conventional fuel volume is likely to be met by biomass-based diesel, is that also right? It's likely to be met by biomass-based diesel?
Yes, so
that's how I read the record. But then that is biomass-based diesel, unless I'm really missing something, can't be used in E10, E15 or E85, and is going to have no effect on the blend wall. And so I just don't, it seems like kind of an apples and oranges bit of reasoning.
So while biomass-based diesel can be used in the total renewable fuel volume, it is not correct that maintaining that space and above the blend wall does not incentivize the increase in E15, E85. So EPA acknowledges that biomass-based diesel can be used to satisfy those excess volumes, but there are increased numbers of fuel used to from 15 E85. And EPA has found that over the years, while we don't expect that, while we certainly recognize that the amounts of E15, E85 aren't going to close the gap, they are steadily increasing over the years. So the record at Joint Appendix 16, 1600, 1601 reflects data for increasing distribution stations for E15, E85 which EPA found was a primary limiter in the ability of those fuels to sort of close the gap in that implied volume. And those have been increasing over the years of the program. EPA assessed that were it to scale down that implied volume at the blend wall, it would essentially eliminate any incentives for those fuels and eliminate their use in the market. So EPA does find that there is value in maintaining that gap, but also allowing parties to use other fuels to fulfill that gap because it creates space for those fuels to grow, even though we acknowledge that the full amount isn't going to be used with those fuels. But it does, the EPA explains in the record that it does support the growth of those blends.
So they're basically saying, we're going to try to use this additional biomass-based diesel or non-cellulosic advanced biofuel standard to both push the non-cellulosic advanced biofuels and implicitly push conventional biofuels. And they're sort of thinking those two things are both happening in the way they've set that non-cellulosic advanced biofuel volume.
I believe that's correct. So effectively the tailoring of the lines here both ensures that, as the volumes show and as EPA's projections show, the non-cellulosic advanced biofuels are expected to increase in production. The program does provide incentive for the increase of those fuels, but also that not quite tailoring the line up to the blend wall allows for space for the amount to grow above the 10% blend wall area.
And what's your response to your colleagues representing the refiners that talk about this price convergence, that the price for conventional renewables is going to rise because of the way you've treated these two different categories? Is that wrong? They say you acknowledge that it's right.
We do acknowledge that the price in that category has increased as a result of that gap in the volume. But we also explain that increased price does provide increased incentives for use of renewable fuel, especially the E15, E85 blends, and that part of that incentive is to provide the increase for those fuels. So while we recognize that there is the increase in the price of RINs, that's an expected effect of the program, where the program is designed to increase the consumption of renewable fuel. The RIN prices are expected to rise in kind.
So it's not, is it that the conventional fuel price is affected by the price of the non-cellulosic advanced biofuel, or it's just that given the relative need for pressure to raise the volume of conventional biofuels, the price is going to go up, whatever happens, separately to some other price of some other category? The converge is what, and maybe I'm overthinking it, but the term converge is that's just a practical analysis. It's not like there's some effect of the one on the other, or is there?
I believe there is an effect. So the availability of, let's say, D6 RINs in the pool for the total renewable fuel volume, it reaches up to a certain number, and the fact that you need additional RINs at a higher price to fulfill that gap causes the prices to sort of meet at a certain point. And so that, to that extent, I believe that's addresses the converge question, Your Honor.
Shifting a little bit, can you explain the illustrative analysis that EPA undertook to compute the climate change benefits? I have to say, in a program that is specifically aimed at energy security and at climate benefits, the range of values for climate that the literature reflects, and as your environmental friends were saying, EPA's restraint from choosing which of the figures in the literature it thinks is most rigorous and most that it's willing to favor. How can it be non-arbitrary to just have this range that the polls of which have very different implications for whether this is a climate saving or a climate harming program.
So EPA conducted as the record reflects, a literature assessment of the available science on climate change, which expresses a range regarding all these different fuel pathways. EPA created criteria for what types of studies it would include, one of them being that it has to be a life cycle analysis and it has to be a peer-reviewed study or come from a credible government or NGO entity to determine what studies fall within. And EPA looked at these studies and determined that they each have their relative strengths and weaknesses, and it wasn't appropriate, at least at where the current state of the science is, to start ruling these out or cutting these out. And EPA created a range of these studies and notes in the record at Joint Appendix 1436 that the trend of these ranges is that the life cycle analyses estimates for renewable fuels tend to be lower than those for petroleum fuels. EPA looked at this range. EPA considered it as it's required to do in assessing the environmental factor, and on the balance determined that the potential for benefits provided by the greenhouse gas reductions from renewable fuel justifies, or at least part with their factors justifies the increased volumes here.
You did two calculations. I'm just trying to make sure I understand the mechanics of how you thought about this, right? So you look at the literature on emissions and you see this huge range. And then when you try to monetize, you do one set of calculations, which is low biofuel, high petroleum emissions, right? And which would be most favorable for the program. And then you do another one, which is high biofuel, low petroleum, right? Which is kind of going on the other end of literature, right?
Yes,
and you do, you have another huge source of uncertainty on social cost of carbon, and you have the kind of your best guess reflected in the three columns, and the 95th percentile is the outlier. And then you have three different discount rates, and the 5 and 2.5 are the outer bound, and the 3% is the mid-range, right? Do I understand it?
Right.
Okay, so if you do the favorable to the program, biofuels have low emissions, petroleum has high emissions, and you take the intermediate discount rate, and you've given us a table of numbers extending 30 years, which you say are the climate benefits on all of those assumptions discounted to present value. If you add up all those numbers, you get a climate benefit. If I did the math right, you get a climate benefit of about $7.5 billion over 30 years. Is that right? Just summing the numbers in the column.
I'd have to look.
I mean, I don't want to hold you to the number,
Yeah.
but am I summing the right numbers? I'm on JA 1506. Just looking at.
I've seen, in adding the numbers, I've seen far higher estimates, but acknowledging that EPA is not holding these out as exact calculations or even relying on these numbers.
But all right, but that is a back of the envelope number that gives a benefit over 30 years that is less than what you say are the increased fuel costs for 1 year, 8 billion a year, which is 24 billion over 3 years.
In that particular column, perhaps, Your Honor, I believe some of the higher ranges provide much higher benefits.
I mean, I'll check my math, but I'm taking the mid rate on low biofuel, high petroleum. And if you take the mid rate on high biofuel, low petroleum, you actually get a negative number. In other words, EPA's table says you go on the other end of the literature, the net 30-year outcome of this just on greenhouse gas emissions is a cost, not a benefit.
Right, that's on the low
If
end.
you just look at it, year one, you're in the whole 15,000 and you're making it up 300 or 400 a year. It's going to, it never catches up.
On the low end, that sounds correct to me, Your Honor.
I mean, the statute requires consideration of cost. How is this a reasonable assessment of cost where on the negative view of the literature, you're getting 30 years of benefit that don't equate to 1 year of increased fuel cost?
So the statute requires consideration of cost to consumers of fuels and impacts of environmental, of climate change and other environmental impacts. And EPA here has assessed the qualitative benefits provided by climate change. I don't have the numbers.
And said it's a huge range and we have no idea, but here's a calculation that's favorable to the program and here's one that's unfavorable to the program.
Right, and that's why EPA doesn't rely at least on that calculation because, again, you're looking at the extreme on one end and the extreme on the other, which is not where most of the studies in the literature land. But if you look at the range of the studies, many of them do reflect that there are greenhouse gas emission reductions, that EPA qualitatively considered those studies and the range of benefits provided by greenhouse gas emissions. And as this court found in the Sinclair decision earlier this year, that assessment is reasonable where Congress has asked EPA to look at climate benefits. It's one of the primary benefits the program is designed to incur. And the issue here is that the science where it currently is does not allow for an exact estimate.
But even close, I mean, it seems like at some point, EPA has to have better metrics because a lot of what it's doing these days, not just in this program, is, for putative client benefits or over client-based objections. And you can't make rational decisions and we can't review their rationality if the range is such that there are major material differences in where within the range reality might be. I mean, I think I trust you appreciate the problem.
We understand it's a difficult issue, and EPA is grappling with it by attempting to consider and understand the full range of scientific literature on this issue, and
coming up with a model that it would actually use.
I mean, so in the record, although EPA didn't rely on it, part of the model comparison exercise was implemented to understand the differences between these studies. Now, for this rulemaking, EPA didn't determine that it wasn't at a point where it could use it to assist the rulemaking, but EPA also explains in the record in response to comments at Joint Appendix 1878, comments requesting that EPA create criteria to further establish and I guess prune out some of these studies or at least narrow down the results. And EPA explained it needs additional time to work with stakeholders and get feedback to reach that point. But the current state of this science is where EPA is assessing it.
Yeah. On this, just much more specifically on JA 1504, this table 4.2.4.2-3, why is it that the numbers in the 2025 line are all negative in terms of climate impact? Is this because this is when the land usage of acreage would occur, and then this is only looking at the these same volumes over time, and so that's then the cash out from the acreage transformation, or what's with the negative at the outset?
That's generally correct, Your Honor. So in general, you note that the trend across the tables is that first line item is usually negative, and that's to account for the impact of clearing the land and generating these fuels, and that's where the negative value comes from. And then that's why EPA looks at it over a 30-year trend, is because you'll have that initial burst of emissions, and then over years you'll get the gains from them replacing petroleum fuels and reducing emissions over the years.
And I take it EPA has not done any opportunity cost analysis, not just hasn't done the ones that your environmental petitioners have requested?
So I'd like
what would be the likely uses of these lands if not for this program? And it is arresting when they say you could use 1% of the acreage for a solar farm and use the rest of it for any number of
So
things,
I'd like to at least
producing food or.
Right. So I'd like to clarify a bit to what they're referring to. So environmental petitioners refer to a particular study that EPA acknowledged in its regulatory impact analysis. This is the Searchinger study, which assesses this carbon opportunity cost issue. And that study, I believe, used a counterfactual exercise, so do not rely on empirical data. And EPA acknowledged the study and explained why it wasn't included in the general range of life cycle analyses, because it's not a life cycle analysis. So to the extent they're saying EPA didn't just ignored carbon opportunity costs, that's not correct. EPA looked at the study and considered it and explained why it was not factoring that into the life cycle analysis.
And there's no other, I guess what I was asking is there's no other carbon opportunity cost methodology that EPA has relied on or developed, because that would seem to be an important, just real world factor when one looks at a chart like this.
So I think part of the issue, though, is that so no, there's not a particular study in that range of studies that EPA relied on, but it explained in its response to comments that to the extent that the study could be, or that type of analysis could be estimated with empirical measurements, so not just assumptions on what landowners might do with their land versus what's currently being used for. EPA explained the current life cycle analysis that it is relying on, or at least that the studies it's looking at rely on, are the kind of business as usual status of these lands that landowners would use in if they were not growing crops for the RFS program or for biofuels.
Okay, well that is an opportunity cost analysis. Business as usual is what you're assuming would be happening. I think that's responsive to my question.
Sure. Yeah.
On another note, the Sinclair decision mentioned Chevron, and you did the two-step analysis with respect to doing an interpretation, but obviously Chevron has gotten overruled. So when you're looking at the cellulose volume requirement, how much are you relying on just kind of the plain text of that statute versus EPA using its own interpretation?
For which?
For just making its own interpretation with respect to the statute. I'm just trying to figure out how much you're relying on using Chevron, since now it's been overruled with Loper. And then our court has taken up the Loper decision on Monday.
EPA is not relying on its own interpretation.
Okay.
The arguments we've made in our brief are all based on the statutory text, so we don't rely on deference or reasonableness here.
Okay. And then just to back up on the sustainability question, you obviously have this program, for 3 years. I think I want to just ask the direct question: is it your position that the program is sustainable over this period of time for the set rule during this period of time?
EPA explains that in the record at Joint Appendix 45 to 52 that on the balance and consideration of all these factors, that the volumes are appropriate, that given the various benefits the program provides to economic development, to job creation, to the increased production of renewable fuels and for the potential greenhouse gas benefits that the fuels provide, that the volumes are appropriate, achievable, and that the program is, I'm not sure the sustainable language, but we believe the program is appropriate as EPA said it.
Another significant category of costs is food costs. The environmental, I think it's the environmental petitioners say that your figures in the RIA say the volumes will increase food costs by $500 per year per consumer unit, which I guess means something like household. And that translates into $6.6 billion per year cost, greater food costs for American families. You have any reaction to that?
So EPA does estimate food prices as the set factors require, and explains that its assessment of the food prices is that they would increase, but that EPA is not viewing that as a cost per se of the program, because the statutory set factors set out how EPA is supposed to look at the different factors. So where it says food prices, in one spot it says cost to consumer of renewable fuel in another spot. So in assessing food prices, EPA did determine what the increase would be, but explained that when looking at cost to society as a whole, that's not necessarily a cost because it's a transfer payment between participants in society. So where consumers spend more on food, farmers, growers, rural communities receive more in food prices. So to the extent that it's entirely characterized as a cost, it's a bit misleading, Your Honor.
And in Growth Energy v. EPA, we made a determination, well, based on you all agreeing that this may have negative effects on endangered species. So why should we come to a different determination here from that 2019 rule?
So my colleague, Mr. Martin, will address the endangered species issue, but to briefly answer, the agency is conducting an assessment in response to that determination and have fully assessed that question.
Great, thank you.
Thank you, Your Honor.
Mr. Martin.
Good morning, Your Honors. John Martin, here to represent the three different federal agency respondents. These three agencies consulted on the effects of this 3-year volume rulemaking for over 2 years, over successive versions of EPA's biological evaluation to refine the data used and the analyses that were employed. And the record is extensive and supports their final empirical judgments that the rule was not likely to adversely affect any of over 800 different listed entities or their critical habitats. The center doesn't particularly challenge any aspect of EPA's technical analyses. And so the court should uphold the ESA consultation in whole as reasonable. The key analysis in this case is the limited connection between the 3-year volume requirements here and the possible land use changes by independent farmers nationwide who may grow corn or soy that could affect any ESA listed species. EPA and the services, the 3 expert agencies here, all found this causal chain too uncertain to demonstrate that EPA's volume requirements will cause demonstrable land use changes or worsen water quality in specific locations that matter for any specific ESA species.
I found that analysis quite implausible to the extent that the brief argues that, well, there could be no effect because the additional volumes could be obtained from increased yield on existing arable land or imported. That could happen. But in light of the past history and the data that EPA has about how increased volumes have led to increased conversion of cropland. I just found that to be, to say that that's uncertainty, that there would be any effect, seems, I know that's not the sum total of EPA's analysis, but that step of it seemed a bit blinder to me.
Well, Your Honor, I would point out, I would make several points in response. For example, soybean EPA found that the possible expansion to grow soybeans could constitute 3/4 of the acreage that might increase as a result of this set rule. But EPA specifically addressed that productivity increases by soybean farmers could account for that entire amount, as well as decreased exports, because our nation exports significant amounts of soybean. So I think these are dynamic markets. I also think, Your Honor, that as EPA explained, the impact of this program varies over time because it's a very dynamic market in biofuels and in these commodity markets. And I guess the third point I'd make is that the record for this rule is very different than the record in prior cases, particularly the growth energy case. Because in this case, the literature in agricultural economics has advanced, where EPA was able to do an attribution analysis that it had never done before. And it found that the requirements for this year had a very marginal effect on the nation's overall production of biofuel and consumption of biofuel, as well as production of corn and soy. For example, only 5%, approximately 5% of the production of corn and soy biofuels are attributable to this set rule requirement. And then I think you have to pair that with the fact that ESA consultation is species specific. And so what EPA analyzed here was whether there would be a bullseye over a bullseye in effect, whether within a species range, which species don't occupy at all times, or critical habitats. That's one bullseye. The other bullseye is whether or not any farmers would take action to affect species habitats or within their range. So it's really a bullseye over a bullseye, and it's a very extended chain. And so I'd point, for example, to my environmental colleagues' point that they would hold EPA responsible for harming any species as a result of farmer decisions. And I think just pointing that out loud illustrates the very, very uncertain causal chain here, that EPA's renewable fuels program under the Clean Air Act would be responsible for sort of aggregate non-point source water pollution by farmers in corn and soy already.
I think what they're arguing is that it would be responsible for an incremental rise in aggregate non-source water pollution. And the notion that an incremental rise of 1% in watershed runoff that then accumulates into a river, that seems non-trivial in light of the figures that EPA itself has included in the record. So it's a little hard to take that careful analysis that EPA did of potential marginal species effects and understand how they become insignificant.
Well, Your Honor, I'd point out EPA also used worst case scenarios and the maximum impact. And I'll talk about the water quality. For example, EPA looked at the Chen study, the SWAT model, and found that the increases would be on the order of 1% at the mouth of the Mississippi River, which was one of the more significant water basins. The National Marine Fisheries Service looked at that and found that there's already a significant amount of existing water pollution. And an increase of 1% in the magnitude of, say, nutrients or sediment loading or pesticides would be within the natural variability of exposure. Because again, I'd like to make the point that there's two critical elements to the analysis here. One is whether species will even be exposed to environmental changes. And the second would be their responses. And the National Marine Fisheries Service also went on and looked at the responses and found that had several pieces of evidence to support its conclusion that increases of 1% in exposure would essentially not lead to any detectable responses in the species.
So help me out with that. So EPA and National Marine Fisheries Service made this insignificant conclusion regarding the effects of incremental additional water pollution. But why wouldn't EPA be able to measure? And part of it is this variability point, that there's other sources of pollution, that the concentrations really ebb and flow, they really change over time. And only, as you point out, only if a high concentration will hit the species that was present would you have a problem. But that just seems like that's a data issue. And it's unclear to me why EPA wouldn't be able to measure a sustained increase in pollutant concentrations, even if there's lots of inherent variability in particular pollutant concentration levels and species response in any one place. Like that just seems like that is a classic data analysis challenge. And the notion that raising an input because of such variability becomes indetectable in terms of any effect it might have. I'm having a hard time seeing that as not just a sweeping under the rug.
Well, Your Honor, I think the easy answer is the dose makes the poison. The National Marine Fishery Service did discuss that when you're looking at sort of the downstream effects, as in contrast to their other scenario about proximal effects in smaller tributaries, the downstream effects, the effects of pesticides and nitrogen and phosphorus, nutrient loading, would be diluted throughout the much larger water bodies it would get to. And so I think the National Marine Fisheries Service and EPA wrestled with that question. They also made specific determinations that there were no more analyses that could be done under existing models or existing data to be done. And I think that's a critical point in ESA case law, that if the technical expert agencies have determined that this is the best available information, it's a high bar for challengers to say, well, you should do more. I think that EPA will continue.
You should study more is really what they're saying. Just that you should study more.
Well, but the ESA statute requires the use of the best available commercial and scientific information. There may be, and there certainly will be, more and newer information in future consultations, because EPA will be consulting on future volume rules going ahead. I think this will develop. I think, as this court has seen in the prior cases and in EPA's analysis, this is a very vibrant market, and more information will be forthcoming. I mean, for example, the attribution analysis here is new.
Right. So, but the land conversion would happen pretty promptly under the tables that we were just looking at when Mr. Papuro was standing at the podium. On the discountability question, so I appreciate that EPA constructed a worst case scenario and, to determine the set rules potential effects, but then asserted that the effects were extremely unlikely to occur because the agency had used a worst case scenario to derive them. But what I'm not seeing, and it may be there, but I just didn't see it discussed in the brief, was any evidence that the worst case scenario is extremely unlikely. Like, we don't know, and whether, if it's a worst case scenario, but what's likely is, something less than that. Do we have any sense of how unlikely?
Well, Your Honor, I would focus the court on a different aspect of EPA and the service's findings. And that is, within the worst case scenario, there will be perhaps 500,000 acres converted. And the agencies, despite their many analyses, were unable to identify the locations with any certainty where that would occur. And so discountability gets to whether the effect will be manifested in a location that matters to any particular species. And to use the water pollution example again, there are large land areas that are species ranges or critical habitats. And if the land conversion occurs a half mile away from a water body, that's not necessarily going to be a source of nutrients. And so the inability to identify specific locations that are attributable to the marginal impact of EPA's program, that's the uncertainty.
But you're not giving the agency credit, because EPA did delineate an action area. And yes, it was probabilistic. And, as you point out, a lot depends on which areas would actually be crop expansion. And then Fish and Wildlife Service said, we're well, we can't delineate an action area. How is that not in conflict with what EPA itself did?
Well, our briefing points out that EPA in its evaluation said we could have made a no effect finding here, but I think taking the lessons of the growth energy decision and the AFPM decision before that to heart, committed to consultation here. I would point out though that when we haven't really talked about the Fish and Wildlife Service concurrence, Fish and Wildlife Service did not jump to the last step of using reasonably certain, as was discussed with the environmental petitioners. It was really looking at the first step, because if you pull back, the concurrence letters are talking about ecological risk assessment and generic about exposure first. First consider the degree of exposure and the magnitude of the exposure and the likelihood of exposure before you go to assessing species response. So EPA was like,
they kind of disagreed with what EPA did. EPA said may affect, and Fish and Wildlife is looking at your biological evaluation and saying, well, actually, we don't agree. We think there's no may affect here. We think there's no effect.
because Fish and Wildlife Service applied its regulations. And as we pointed out in the brief, this is a common occurrence in informal consultation where an action agency like EPA comes and says, we think this may affect, but we think it's not likely to adversely affect. I think I would point out, though, that in the end, all three expert agencies concurred essentially that this was not likely to adversely affect specific species, particularly because the agencies could not identify the specific locations in which any particular species would be occurred. There's no basis in the ESA to look at cumulative risk, to sort of compound and add together all the probabilities and say, because one individual of one species might be harmed, all 800 plus species need to be analyzed. The agencies were forthright in saying there are no more analyses to be done. The existing models don't allow this projection. The existing data doesn't allow this to be done. And I think that's a task for future consultations.
So I had asked environmental challenges about this, but the consultation handbook says that no effect is the appropriate conclusion when the action agency determines its proposed action will not affect a listing species or critical habitat. And here the action agency is EPA, right?
Correct.
But you don't understand that to mean that Fish and Wildlife Service itself is not permitted at this threshold stage to make a no effect conclusion when the EPA has already concluded that there may be effects? You're not reading the handbook that way?
No, Your Honor, because our briefing pointed to, it's page 3.3 of the consultation handbook. It's a flow chart for an informal consultation process. That's at JA 2133. And it points out that in informal consultation, the service can say, actually, we get the final decision on the nature of the effect. And here it said, this is an appropriate no effect determination because it explained how it approached whether or not a species would be exposed by applying the two-part definition of effects of the agency's action. It said, well, EPA designated an action area, but that's an area where corn or soy or canola could be grown and species could be affected, plus all downstream areas. So EPA was very open to the service's input and went to the services sort of with this full panoply of findings. And the fact that Fish and Wildlife Service concluded its analysis based on lack of a reasonably certain exposure, National Marine Fisheries Service went one step further and actually looked at some of the other effects. And the two concurrences are actually mutually reinforcing. And the fact that they came at it from differently, I think, lends probative value to the fact that all three agencies agreed here.
Can I just ask you how the regulations, it's the same question I asked your friend. How do the regulations work if there is a proposed agency action that is likely to have an adverse effect on some species, but not reasonably certain to have an adverse effect on a species? Right? It would seem if you look at 402.14, you can't say that it's not likely to adversely affect, so you have to do formal consultation. If you go back to the definition in 402, you would say, well, it's not reasonably certain, so there's no effect at all. It just seems hard to reconcile those two.
Well, I think ultimately these are fact-bound determinations ultimately by the services. And I think the services
Yeah,
can.
but determinations of what? Likelihood or reasonable certainty?
Likelihood. Ultimately, the findings here are the ones in the regulations. Can the agencies all agree that it's not likely to adversely affect? And that requires application of the effects of the agency action definition.
You don't think it's reasonable certainty is?
Reasonable certainty applies in the informal consultation, as Fish and Wildlife Service explained.
So it didn't Fish and Wildlife rely on that, though, to say no effect? And this is not a
But-
formal consultation context.
No, this is not a formal consultation. They did an informal consultation.
Right, but it seems to me that they relied on the not reasonable certainty rule.
They did. They applied the effects of the agency action definition in informal consultation, as is permitted by the regulation, as they've done for years, as we demonstrated by proffering an earlier solicitor's opinion on that topic, solely for the point that the agency is using the same practice for years, didn't need to explain any change under
I mean,
Foxville.
then the reasonably certain standard in the definition just seems to completely overtake the substantive standard of, is it likely or not?
Well, I think reasonable certainty and likely can be reconciled.
I think 55% sounds to me like that would be likely, but not reasonably certain.
We long resist using percentages and quantitative because many of the
Do
judgments.
you equate likely and reasonably certain?
Yes, Your Honor.
Okay. And you're not seeking Kaiser deference?
We're not saying, we don't think there are any true Kaiser questions raised by the center's briefing. Because there's no text to construe
No,
here.
it's not clear from their briefs, but I'm just reading these two regs, having a tough time reconciling.
Well, Your Honor, and I guess one point I would make is that there was a question to the center's lawyer about affect and effect.
Right.
I think the handbook at
Handbook equates the two.
JA
We've done
2121.
that since, right.
Yes, it if you affect something,
Which-
you induce an effect.
Heightens my puzzlement that likelihood seems to me a good bit lower than reasonably certain. But maybe you read those terms differently.
No, I think the agencies struggle with this in the context of fact-bound questions for particular species and particular scenarios. And they don't necessarily need to quantify those.
Okay.
And it's the strength of the evidence as well in some instances, Your Honor. Thank you, Your Honor. If there's no further questions, I see I've gone well over.
I have a question about the affected area analysis, why EPA used this, what it describes as a probabilistic methodology to estimate where cropland conversion was going to occur. I take that assumes that every acre of land identified is equally likely to be converted. And I wondered whether there isn't really robust data about historical cropland conversions that might be more accurate in predicting the actual location of future conversions. I mean, something that's adjacent to an existing farm or where near to a biofuel refiner, or, I mean, so I just, it seemed like there's probably a lot more accurate location data available.
EPA did wrestle with both of those questions, Your Honor. In the biological evaluation, EPA explained in doing the analysis of corn that maybe in earlier years of the program, conversions were located closer to refineries. But as the program has matured and currently, and under the data here, EPA concluded that the price effects for corn was a more significant driver of potential land conversion. And so it's not close to refineries. I think that also EPA, when it did the overlap analysis, the potential land that could be converted for soy, which again is most of the acreage that EPA found could be converted here, it did use a weighted model to choose lands closer to currently under cultivation for soy. And that was existing data because again, there's a huge amount of data to wrestle with here, and EPA was careful to select the best. It was possible to do so with the soy, less so with corn because it's much more widespread.
And Do we know anything? Do you know anything about the result of the ESA related remands to the 2018 and 2019 rules that the court ordered in PM and in growth energy?
Yes, Your Honor. EPA does intend to complete those remands. There were pragmatic considerations to focus its resources on this consultation for this rule so it could be done before the rule was promulgated and put into effect. Adding in other years into the same consultation would have brought in much more data that would have slowed down the process. In particular, because this is EPA's first consultation, it's thought best to focus on this rule to get it done. There was a settlement with the center petitioner to get this done in time, so this petition could be adjudicated. But EPA fully expects to address those remands once it knows if it has a valid approach here.
And what about baseline? In your brief, it seemed like you were suggesting that EPA is not required to provide the services with a baseline during informal consultation, but it's hard for me to understand how an analysis of effects could be accomplished without some baseline.
I guess there's 2 points there. One is we make the point, and this is perhaps the minor point, that the term environmental baseline is required to have its own section and to be addressed separately only in a formal consultation. This was an informal consultation. I think, though, that the agencies here did wrestle with the baseline, and EPA looked at the effect of this set rule by determining what would be the volumes consumed and produced, et cetera, with and without this rule. And because that's intended to identify the consequences of this action. I think that's fully consistent with the ESA definition of environmental baseline, because the whole point of that definition, if the court parses the definition, is to identify the consequences with and without the proposed action. So I think EPA and the services did use a baseline in the broader sense of the term to identify and isolate the consequences of this action. What the center is seeking is something much broader, and the term environmental baseline is not so broad to include what they require, sort of a retrospective assessment of the cumulative impacts of the program itself. Because again, it's dynamic and it switches over time. If the purpose of any baseline analysis is to identify the with and without or the consequences solely of the proposed action, that's not what the center seeks here, and that's not, there's no basis in the regulations for that claim.
Although there's a little hole empirically in the baseline because, for example, the 2018 remands, 2019, none of that has been done. But I take it that the unit that you're analyzing is the effect of this rule, incremental effect of this rule.
And that is the task for ESA here, Your Honor. Thank you.
Thank you. Is it Mr. Lane?
Yes, Your Honor. David Lane for the Biofuels interveners addressing the refiners brief. May it please the court. The refiners are wrong about how the set works. The congressional purpose of forcing increased renewable fuel remains. It didn't end at 2022, and Congress didn't give EPA the discretion to cancel the program. EPA's approach recognizes that much, but still involves very significant policymaking discretion to balance the set factors according to some kind of cost-benefit analysis. Loper-Bright teaches that we need to be more sensitive to whether Congress made policy judgments itself. And we believe that Congress already made policy judgments to balance the program's incommensurable and sometimes indeterminate benefits and costs. And those judgments structure and constrain EPA's set factor analysis. Specifically, EPA must set standards at the highest achievable level that will yield statutory benefits unless EPA foresees that that volume would cause widespread, severe economic or environmental harm. This standard reflects the RFS's original.
Sorry, where are you getting that? Post table, the standards are set by these 6 factors that seem very general, and they cut in opposite directions, and who knows how they cash out.
I can go in 2 directions on that, Your Honor. One is that the standards are just telling EPA what to measure. Or sorry, the factors are just telling EPA what to measure. They're not telling EPA what to do with those. They're just raw inputs. How much cost, how much production, how much consumption, how much environmental benefit. But it doesn't tell EPA what to do with that. And to leave it open to EPA, that's a very significant amount of policy discretion to just say, EPA, do whatever you want, balance it however you want. These are incommensurable things. We've been talking all morning about how difficult it is to measure some of these things. Do we really think that that's what Congress was doing? I think there are a number of clues in the statute that tell us that there's a more structured approach that EPA is supposed to take. And I can list them for you. The original volume table is very aggressive. It's a 9-fold increase over 15 years. The reset triggers.
I mean, cellulosic didn't work out so well.
And that was the only one that didn't, but it still reflects, it reflects the idea that Congress wanted to push the market to do a lot more than it was doing. The reset triggers have thresholds of, if Congress overshoots by a wide margin. What does that tell us? It tells us that Congress thought it very well might be setting volume standards that were going to overshoot by a wide margin. The general waiver tells us that Congress thought its standards might be so tough that they would cause widespread severe harm. And deliberately setting volumes below the severe harm level would nullify the waiver. And the waiver again tells us that reduction is appropriate only when there's widespread severe harm or when there's inadequate supply, meaning it's not feasible. So this is the program that Congress set up in the beginning, and then the set comes along, and what we think Congress is saying is, look, we could only foresee at best 15 years in the future. We don't have a crystal ball. So we now want EPA to do what we did. We considered a wide range of considerations. That's the set factors. Everything that goes to what's achievable, everything that goes into the benefits, everything that goes into the costs. Look at all of it. And then with the lens that we applied, where we have judged, we Congress have judged that achieving very aggressive displacement of fossil fuel with renewable fuel is important for good reasons that may not always be measurable in a monetizable way, but pursue that.
Is it a technologically achievable standard?
It has proved to be technologically achievable with the exception of cellulosic.
But is your position EPA has to set the highest volume requirement that is technologically achievable?
I think, EPA could start from how much do we think the market's going to be producing or could produce if it had
Factor 3
signals from the RFS itself. The market can respond to the RFS signals. So if we set targets at this level, could the market meet that in terms of production, in terms of distribution, in terms of consumption, right? And if the answer is yes, then we can set it there. If the answer is no, then we bring it down to the level that the market could actually get to. And then EPA can say, all right, would that actually yield any of the statutory benefits? We don't have to monetize all of it, but we just have to confirm that this is still serving.
How does the cost factor?
So then if it cleared that second hurdle, then EPA could think about costs. And EPA could say, look, we know there's going to be costs. Sinclair.
The greater the benefit, the greater the cost, right? And presumably it's not linear.
I don't know if there's that kind of relationship, but I think one of our points here is that that comparison Congress already did. That's not for EPA to do. The comparison that Congress did is, as long as there are benefits from these aggressive volume targets, only severe harms can justify a reduction.
You keep referring to the severe harm reduction, but isn't that for the statutory volumes?
Well, it's still available. And if EPA were to now deliberately set volumes at levels that it knew would never trigger a severe harm waiver, the severe harm waiver provision would be pointless. And Congress didn't say the severe harm waiver, sunsets after 2022. It still has to play a role. I think timing is an important part of this. The volume table was set up way before the compliance years. And the waiver provisions are available to use sort of at the last minute or in the middle of the compliance year. So I think the idea is, let's set very aggressive goals. Let's see if the market can get in position to meet those. And if it turns out that there's a serious problem when the time comes, EPA has flexibilities to address that. The set is like that. The set calls for EPA to set a new volume table effectively at least 14 months in advance of the first year that it's doing it for. And then it has these waivers on the back end in case there's a problem.
So what's the particular error that you're asking us, for which you're asking us to remand?
Well, we're defending, I want to be clear about our posture. We're defending EPA, but the refiners have raised a challenge to really what is the purpose of the set? What is EPA supposed to be doing when it implements the set? And the refiners have said effectively nothing. They want the program to go away because it costs them sales of their products. It displaces their product with renewable fuel. So their position is the set does nothing, there's no purpose. EPA responds, no, the purpose is to increase renewable fuel use. And when we just balance these factors in some way that generates all these questions we've been debating all morning. And our answer is, well, EPA is partly right. The purpose is to increase renewable fuel, but there's a more structured analysis to conduct. It's not just a straight up cost benefit analysis. It's one that reflects the original structure of the program. I'm quite a bit over time, Your Honor.
Right.
Well, you mentioned that the EPA does not have to deal with the cost, but how do you think the court is supposed to view the cost?
I think so on this rule, we're not saying if you were to agree with my characterization of the framework, we don't think that would then justify a remand or a vacator of the rule. We think that EPA, what it did is good enough for government work in this instance, and we didn't challenge it on this basis. But insofar as the court is going to articulate what the set process is, what is EPA's task, we believe it's important that we present to you what we think the right answer is so that, ideally you would articulate the right answer in your opinion. But we're not asking for a remand on any of on the ground that's inconsistent with the framework that I'm articulating here. If I could have your indulgence, I would say one word about a different topic, but I understand I'm quite a bit over time.
20 seconds?
Okay, just to try to clarify on this question of the implied conventional level and the convergence of RIN prices. Empirically, RIN prices do converge, but where you place that line doesn't affect RIN prices. What affects RIN prices is the total demand for the renewable fuel. All that line is doing is actually squeezing out ethanol.
Or allowing it not to be ethanol.
Yeah, and so
compliance flexibility is one way to think about it.
It is, and what would increase RIN prices would be setting the advance at the level of all advanced, and then setting the implied conventional amount at the level of all conventional and being more aggressive. It's the aggressive part, it's the more demanding part that raises RIN prices, not where you set that exact line. Thank you, Your Honor.
Thank you. Morning, Mr. Schenkman.
Good morning. May it please the court, Ethan Schenkman for Biofuel Interveners. I'd like to start with the ESA issues and then also address the climate benefits findings under the set factors. I'd like to start with Judge Plard's question, isn't there more accurate location data available now empirically? And the answer is yes, there is. And I would implore the court to read the science amicus brief, which talks about, based on evidence in the record, that what was thought to be historically land use conversion has actually historically been bringing previously cultivated land back into crop production. There's been a miscategorization.
We can't review based on studies that aren't for us in this record.
The majority of the studies in the amicus brief are in the record. In footnote 3, they cite to every single page where the science amicus authors themselves authored reports. So they are utilizing evidence in the record. And to your point, Judge Blard, about historically what has been the pattern with land use, actually corn acres have remained stable since 2007, which is when the RFS program started, and that's at JA 1259 and JA 608 to 609. I'd like to turn to Judge Katsas's question about the definition of effects. The definition of effects refers to consequence. Refers to consequence, whether an environmental consequence is reasonably certain to occur. You can have an environmental consequence that's reasonably certain to occur, but yet later on in the analysis, the agencies determine that it's not likely to adversely affect species. I think that's the answer to your question of how to reconcile these. And I'd like to turn to EPA's biological evaluation.
Sorry, hang on. Let me
Yes.
make sure I get this. I mean, the things that count as effects under the definition should be broader than things that are likely to adversely affect a species under the substantive rule.
I think the definition and the way the agencies have treated it here is that first you have to determine whether there will be any effects of the action. And that's a causation question, because something cannot be considered an effect of the action unless it meets the but-for test and is reasonably certain to occur. If you determine that there will be certain environmental consequences, then you analyze what the impacts on species might be, which gets you into.
At the threshold, the consequence must be reasonably certain.
At the threshold. That's correct, Your Honor. And that's critical because when I want to turn to EPA's biological evaluation, EPA finds throughout the biological evaluation that these consequences.
Let's stick on the interpretive point.
Okay.
Maybe I'm getting spun around the axle here, but suppose I think there's an adverse consequence and it's 60% likely to occur. And I think that is likely. It is not reasonably certain. How do I apply these regs? If I'm applying the operative rule, I would say, yeah, it's likely, so you need to consult. If I look back to the definition, then just seems to completely outstrip that in that mid-range of things that are likely but not reasonably certain.
And
there's no effect at all. Am I missing something?
Well, I'm trying to distinguish between the environmental consequence and what the effect on the species will be. So here, the environmental consequence is land use conversion and whether there's going to be additional, nitrogen and.
I thought you just flipped it. I thought I was following you and that you were saying the effects are any effects of the action, which would be, for example, land use conversion.
Yes.
And then you were talking about likely to adversely affect the species, that was a consequence. But then you just said it the other way around. The threshold is a broader category. The effects
of the action. The effects of the action is a threshold inquiry, and this is consistent with the analysis in Maine lobstermen. What are the potential environmental consequences that we're talking about? Will there be land use
consequences to listed species or critical habitat?
Or just effects more broadly? That's what first question?
It's the environmental effects, which are relevant to the species. I mean, if there's going to be land use conversion and additional, nitrogen loads, et cetera, that is something that's relevant to species. But then you have to get into if you find that those effects are reasonably certain to occur and meet the but-for test, then you have to get into a more nuanced evaluation of what the impact to the species are, like NIMFS did. And that National Marine Fisheries Service looked at not just what sort of exposure would be there would be, but not just exposure, but what would the response of the species be to that likely exposure. But my point, I would like to, I think it would help if I can turn to what EPA and the Fish and Wildlife Service actually did here. In the biological evaluation, EPA makes numerous findings that these environmental consequences are not reasonably likely to occur. And EPA says that this would actually support a no effect determination. That's at JA 1204. EPA also finds not reasonable.
EPA went down both routes.
EPA could have taken an earlier off-ramp.
They said not reasonably certain,
Right.
Therefore no effect.
They could have stopped there.
In the alternative, no likely effect under that discountable standard.
Not likely to adversely affect. Correct.
They did both.
They did both out of an abundance of caution, but they could have stopped.
Fish and Wildlife only did the first.
And took the earlier off-ramp, which was completely justified under Maine lobstermen. EPA it's throughout the record, JA 1108, 1252, 1027, 1253, explains why at each step of the causal chain, there's a lack of evidence that the environmental consequence is reasonably likely to occur. But then EPA says, out of an abundance of caution, we will consider the worst case scenario. We will make all these sorts of assumptions. Like, for example, there is more than enough ethanol that is produced in the United States today to satisfy all of the increased volumes in this rule. And EPA recognizes, therefore, there may be zero additional production of biofuel caused by this rule. But nonetheless, we will assume that 100% of the additional volumes are satisfied by additional production. And then you go on down the chain to the effects on farmers' decisions and what crops they rotate and what pesticides they use and what fertilizers they use, et cetera, et cetera. Each part of the causal chain, EPA concludes that one cannot conclude with reasonable certainty that this environmental consequence will happen. And so EPA could have stopped there. What the Fish and Wildlife Service did is it looked at all of those findings that EPA made and said that justifies a no effect determination, and we're going with that. NIMFs, like EPA, went above and beyond what was required and did a perfectly reasonable and very robust analysis, but all three agencies could have stopped at a no effect determination under Maine lobstermen. Finally, Your Honor, I'd like to, if I may, just address the climate benefits for 1 second. Petitioner's argument that EPA never concluded that the rule has climate benefits is just false. In the preamble at JA 48, 50, and 52, EPA found that greater volumes of ethanol and soy-based biodiesel and other renewable fuels correspond to greater reductions in GHGs as compared with diesel or gasoline. And this is supported by three things. First, and this was missing from the argument to this point. EPA did a life cycle analysis in 2010. EPA's 2010 life cycle analysis found that corn ethanol meets the minimum 20% GHG reduction requirement and that soy-based biodiesel meets 50% minimum GHG reduction requirement. And EPA saw no reason to revisit that LCA in this rule, and petitioners point to no valid reason why they should have. So that's the starting point. And the illustrative tables are based on the 2010 LCA. They're not based on the literature review. They're based on the 2010 LCA.
Sorry, what is?
Which illustrative tables at JA?
The illustrative tables at JA, I have 1486 and 1482, which found a minimum of 46 million tons of CO2 savings to a maximum of 1.5 billion tons of CO2 savings over the next 30 years. And that's all biofuels together, all renewable fuels. EPA, the illustrative tables show, Judge Pillard, to your question, yes, it's a big range, but any way you slice it, there's at least some benefit. And those illustrative tables are actually using EPA's original 2010 life cycle.
Hang on, they are distinguishing two scenarios depending on how much better, if any, the renewables are.
Yes.
One they call low biofuel, high petroleum emissions, and the other they call high biofuel, low petroleum emissions. I had thought that reflected the range in the current literature, but regardless of that, it reflects some range of uncertainty. So yes. Where is that coming from?
And a perfect visualization of this for you is when you turn to it, JA 1443 has a figure. It's actually a figure of the literature review. It shows 19 estimates from 9 different studies.
It's in the RIA. I got it. Now, what's the page?
It's at JA 1443.
Yes.
This is 19 estimates from 9 different studies. One of the studies is EPA's.
Sorry, from 2010?
Sorry. No. This is just, sorry, let me explain.
Go ahead. I'm sorry.
This chart is the literature review, right. But the literature review includes EPA's 2010 LCA. Correct, Your Honor, 1443. And you'll see that there's 3 entries for the 2010 LCA. Now, why is that? Because the 2010 LCA had a low-end estimate, a high-end estimate, and a mean estimate.
I'm sorry, where are you getting the 2000?
Okay, so if you look at the number 49
Where's
on the table, it's the fourth one from the bottom.
And 91?
49 towards the bottom?
Yes,
Okay.
49 on the chart.
Okay.
That's the low-end 2010 estimate.
Oh, I see. RFS 2 rule 2010.
Exactly.
Okay.
And then if you go up to the number
Where's the mean?
73, that's the mean 2010 estimate.
Okay,
And then if you go up to, I guess it's 91,
91.
that's the high end. And the illustrative
So
table
the high, low, and low, high are the endpoints of this.
of 2010,
I see.
right? But what
Okay.
really mattered in 2010 was the mean estimate, because that's the one that EPA relied on to show that ethanol meets the minimum GHG reduction requirements in the statute. And this is the last point I'll make, is that if you look at the mean estimate at 73, well, and you just look at the most recent studies from 2019 to the present, almost all of them show greater GHG benefits for ethanol than the mean estimate that EPA came out with in 2010. And the only ones of the recent studies that are higher are basically this one study by Lark. And Lark's study is other government agencies in this record have pointed out the fundamental flaws in the Lark analysis, and that's at JA 468, 477.
Put Lark aside. They have it in their review. I cited it last time. People think it's wrong. Who knows? I'm not going to decide based on.
I'm not arguing it should have been removed from the list, but that the weight of the evidence is that the majority of the most recent studies show even greater benefits than what EPA had estimated in 2010. And basically all of the ones that show less benefits are from this one study where there's a lot of other studies in the record that discredit it. And so the vast weight of the evidence supports EPA's finding that there's a directional correlation between increased biofuel consumption and GHG reductions.
If I were to care about some ballpark assessment of costs and benefits, notwithstanding your friend's argument, what's wrong with the back of the envelope calculation that I took government counsel through, which is they present a low-high scenario, they present a high-low scenario, take the intermediate discount rate in each of them and sum up the benefits, and it's either about $7.5 billion over 30 years or it's essentially nothing. The climate benefit. Those are their tables.
Well, I think my answer to that is simply that in Sinclair, this court said that it wasn't necessary to quantify or monetize, but that if you look at what's missing from EPA's table, they didn't give was a table based on the mean. That you see on JA 1443, the mean, that's the number 73 grams of CO2 per megajoule. And so if EPA had a table that was based on the mean, it would be somewhere in between the high-end estimate and the low-end estimate.
But isn't the point that the mean isn't necessarily something you can just deduce from the high and the low, depending on whether there's a curve? Because here, the mean isn't halfway between the high and the low for 2020.
Correct. I can't explain to you right now statistically why that's the case. I'm just reading to you what it says, that it's the mean. And the mean is what EPA actually, in 2010, to find that ethanol meets the 20% minimum GHG reduction requirement and that soy-based biodiesel meets the 50% reduction requirement, EPA relied on the mean estimate. So
Thank you.
Thank you very much.
Just a few points, Your Honors, on rebuttal, if I may, very quickly. First, as to the conversions question, I'm sorry I didn't have this before, but if you look at page JA 517, there is an Energy Information Administration chart showing that the price of ethanol rises to meet the price of biomass-based diesel under EPA's program. But this goes back.
Can you give me that site again?
I'm sorry, JA 517. It's in a comment.
Yeah.
And EPA, as noted, didn't dispute that. But this goes back to the larger point about the purpose of EPA's set rule and how it's supposed to be approaching this program going forward. Obligated parties are not asking for the court or EPA to cancel the program, but if Congress had wanted EPA to look only at the maximally achievable value minus waivers, it could easily have said that. Instead, Congress very clearly said, look at a review of the implementation of the program during those years. So how did it work out? Not what was the percentage growth Congress wanted, but to look at the implementation and then an analysis of the factors, including potential projected future production and cost and all these other things. And that is where EPA fell down here. EPA intentionally set the levels at a way that it would increase cost and it would harm obligated parties and the cost to consumers generally. Also, had Congress wanted to artificially increase the volumes to their maximum amount, Congress wouldn't have included the cellulosic provision that expressly instructs EPA not to set cellulosic, at a level that would require it later to issue a waiver, which is what EPA in fact has done here. And so for all those reasons, unless the court has any questions, we believe that the court should remand.
This isn't technically a rebuttal question, but I had a question left over about the supplemental standard, and you argue that EPA failed to consider why the court invalidated the use of the waiver in 2016. How, in your view, would the cause of that invalidation affect the treatment of the supplemental volumes?
Well,
in
Your
this
Honor,
case, or their validity?
Thank you, Your Honor. That goes to the question of what EPA could have done instead of issuing the supplemental standard that it issued here. Recall that back in the ACE case, there was a leftover amount of cellulosic waiver volume that EPA could have applied instead of the inadequate domestic supply waiver. And so we were arguing that EPA should have looked at the circumstances in 2016 and whether it would make sense to continue to apply some of that waiver authority.
Okay, got it.
Thank you.
Your Honor, unless there are further questions from the court, the small refinery petitioners will rest on my affirmative presentation.
Okay.
Your Honors, I'd like to start by addressing something that interveners just said at the end of their statement, which was that we were looking at the means of these values. I just want to note that at JA 1434, EPA expressly says, quote, "We intentionally do not calculate or present any statistics, e.g. mean, median, derived from the estimates included in our literature review, as we do not believe such statistics would be meaningful or appropriate based on the design of our literature compilation." So EPA itself, as opposed to counsel in this case, never looked at any sort of statistics about the studies. And the means that are reflected in the record that you were looking at and that counsel referred to were the means for the 2010 model, which EPA itself throughout the RIA says is outdated and needs to be updated. And that brings me to the point that I didn't get to address earlier, which was about the model comparison exercise and EPA's intent with this. I want to clarify that EPA conducted the model comparison exercise because the model it was using was based from 2010, which is quite outdated, as EPA itself acknowledges. Instead, it did this exercise, which used 5 updated models. It used the same inputs, and thus it provided results that were comparable. Whereas with the literature review, EPA says over and over and over again that the results are uncertain and they are not comparable. So the model comparison exercise was actually the best evidence in the record about what the impact of these renewable fuel volumes would have on climate. And in 2 of the 3 dynamic models that EPA looked at, there were significant increases in greenhouse gases for soy biodiesel, which is the fuel that will experience the biggest increase. Turning also to your question about whether carbon opportunity cost is, whether EPA has to use an LCA, a life cycle analysis, I just want to clarify that carbon opportunity cost is actually a life cycle analysis. EPA says it's not, but that's incorrect for the reasons that we discuss in our briefs at page 32, and as EPA itself recognizes at JA 1446. And so by failing to consider this type of life cycle analysis, it ignored an important aspect of the problem. And this isn't just described by Searchinger, this is described by several other academics, and those are cited in the record at JA 531 to 533. Also, in terms of EPA counsel's response to the questions about the literature review, his statements were simply conclusory. And as this court has said over and over again, an agency must explain what considerations it found persuasive, and that's from Rural Cellular. It has also said that stating that a factor was considered or found is not the same as considering or finding it. And that's at Susquehanna International Group. And also that an agency's decision must be one of reasoning and not just a conclusion. So in sum, this program is supposed to be an attempt to help combat climate change, but these volumes actually increase climate emissions. Because the decision here is neither reasoned or explained, it fails this court's test. We therefore request that the court find that the rule is arbitrary and capricious and a violation of the Clean Air Act and the EPA.
Thank you.
Thank you.
And are we hearing also briefly from Ms. Coulter? I wonder if you'd particularly respond to Mr. Shankman's effort to explain how the facially, potentially inconsistent or intention portions of the regulations fit together.
You can start there, Your Honor. So the may affect standard is written to the statutory language, whether there may be an effect on endangered or threatened species or their listed critical habitat or their critical habitat. When we look at the reasonable certainty standard, that comes into play in the formal consultation process when you're dealing with things like trying to establish incidental take statements or likelihood of jeopardy. And so when we're looking at whether we should engage in formal consultation, the likely to adversely affect standard applies. And I can provide an example of how EPA has treated this kind of uncertainty in the past. EPA has routinely consulted formally on actions of nationwide scope that have similar uncertainties, like in the pesticides context. There we aren't sure where or whether somebody might apply a pesticide, and yet that uncertainty as to whether there will be an impact is reasonably certain, but we might not have certainty as to where those pesticides might be applied. And similarly here, when we look at Fish and Wildlife Services determination of no effect concurring with EPA is not likely to adversely affect, Fish and Wildlife Service doesn't find uncertainty with regard to whether the set rule could likely adversely impact species and habitat, but rather that there may be uncertainty as to where geographically that land use change may occur. But as we've said previously, we know a lot about where the impacts could occur. For water pollution, it all flows downstream and aggregates, and we certainly know where this designated critical habitat is located. So it's here the agencies are relying on the vast scope of the rule as a basis for avoiding formal consultation, but it can't be the case that the more widespread in nature the inaction and the more species and habitats that are impacted, the less likely the agency is to engage in formal consultation due to uncertainty. And as this court held in Growth Energy, uncertainty in the causal chain is not an excuse for avoiding formal consultation. There are no other questions. I'll conclude there.
Thank you. And that's no further rebuttals, right? All right. All right, then we will proceed to part 2. Good morning, Ms. Franco. You may proceed.
Thank you. Good morning. May it please the court. Sandra Franco for Sustainable Advanced Biofuel Refiners Coalition. I have at council table Jerry Mize with me. I have reserved 1 minute for rebuttal. For purposes of argument, I will be using the common definition of biodiesel, which is monoalkyl esters. An oxygenated fuel, distinguishing it from petroleum and renewable diesel, it is a low carbon fuel that provides cost-effective greenhouse gas emissions reductions and reduces prices at the pump. Petitioner here seeks to ensure that the Renewable Fuel Standard Program is implemented as Congress intended. That is to promote biofuels through certain minimum volume requirements, including biodiesel. Certainty allows producers to receive financing, make investments and business plans, such as purchase feedstocks for the coming year's production. We believe EPA's implementation of the program impermissibly and arbitrarily disadvantages biodiesel, undermining the certainty that Congress intended. Under EPA's implementation, even refiners have said that increases in renewable diesel will result in decreases in biodiesel. That is, a higher carbon, higher cost fuel is displacing biodiesel, not fossil-based petroleum diesel fuel. The starkest example of this is the unfair treatment that is felt with the equivalence value that is given to renewable diesel, where it can generate 1.7 RINs, which are used to meet the volume requirements for each gallon of renewable diesel produced. Assuming a $1 to $2 RIN, that's a 20 to 40 cent difference per gallon that can be attributed to fossil-based hydrogen that is used in the production process. For 100 million gallon renewable diesel plant, this would result in a $20 to $40 million windfall per year. Today, we would like to focus on the equivalence value of renewable diesel and EPA's implementation of the biomass
Threshold, isn't your argument with the statutory definition of bio-based diesel?
No, Your Honor. What our challenge is that we are in a new phase of the program, as has been stated earlier, and as EPA has stated throughout the final rule, where it is now fully under a set provision where EPA is setting all the volume requirements. And a key part of that is that the percentage standards that it was required to set prior to 2023 is no longer applicable. So EPA was to determine how it was going to implement the volumes. And what it said is we have discretion in setting the volumes and we have discretion in implementing the volumes. And they asked for what are the options we can use?
But this broader definition, I appreciate your frustration with the reality that the broader definition, which EPA adopted, I think, in 2007 and 2010 and 2013, that it is having a much bigger impact now because of technological changes. And I appreciate as a practical matter, that the uptake of these other kinds of bio-based diesel are potentially crowding out your client's product. But I guess one question is how can you say that your challenge to what's now a longstanding definition of biomass-based diesel is timely, given that this is a definition that's been in place, even if not really exploited for a long time?
Yeah, and I understand that, Your Honor. What we're saying is that EPA's defense for not addressing our concerns is that it says, well, our hands are tied because of the definition of biomass-based diesel. And we are saying that's simply not true. First, we think that they're misreading, that they've they've broadly interpreted the statute. And we can explain all of the reasons why we think that. And particularly one of the new aspects is the approval of ethanol to jet fuel, which is based on different feedstocks that were not contemplated back in 2010 or 2013. That was a recent development. And they did not consider those when they set the biomass-based diesel volume.
Well, they did say, and I thought, if I'm remembering correctly, that biomass-based diesel included jet fuel in 2013 and 2010.
Yes, Your Honor, but it did not address, the jet fuel was the renewable diesel that was already in the pathways, which were all lipids, basically soybean oil, animal fats, used cooking oil. They never indicated that the feedstocks, which are starches and sugars that go for ethanol production, would be part of that. And if you look at the definition of biodiesel, it refers to, oils and wastes, and those are all kind of lipids. And, just the common meaning of biodiesel and renewable diesel has always been vegetable oil, animal fats, those kind of feedstocks. So in our opinion, they have also expanded broadly beyond what they were talking about in 2010 and 2013.
But then I think the trick for you is whether that definition is really raised or opened in any way in this rulemaking. And when EPA is soliciting comment on the proposed increase to the biomass-based diesel standard, it's just talking about the level, not the definition, is the counter argument to yours, right? And I guess, to the extent that we think that EPA was soliciting comments on the increased volume requirements, then how does that bring this definitional issue into play?
Yes, well, EPA also asks for other options. And so our option, and we actually provided an option to EPA where it did not need to change any of the definitions in the regulations. All it needed to do was say, all right, for this one, and what the volume we proposed would have been less than what they actually finalized for biomass-based diesel. It was based on existing production, what we've already achieved. It is similar to the candidate volumes that they have in the final rule. And so what we said is that you have discretion to do this. If you look at the statutory factors, if you look at the implementation of the program, where you have said that the Advanced Biofuel Program is doing all the work here. We have asked EPA, what is the purpose of the biomass-based diesel program? We don't get an answer. The Advanced Biofuel is what's driving the renewable diesel production. And in fact, the obligated parties have said, raise the Advanced Biofuel volume requirement. They don't say raise the biomass-based diesel requirement. So in our opinion, under the factors, even if you approve or agree with their definitions, the factors do not, would indicate that they have discretion to say, all right, well, we think to better ensure the volumes, to better achieve these environmental, economic, energy security benefits that Congress sought, that we can establish a minimum, again, these are minimum volumes that EPA is setting, these aren't ceilings, that we can set some minimum volume for biodiesel. And then that way we are supporting the biodiesel production. We're giving them the certainty that we believe was the purpose of the Renewable Fuel Standard Program. Right. And so essentially okay, can I just make a quick comment on the equivalence value? EPA's only defense there is simply that they're considering other regulatory provisions, and we think the equivalence value is distinct and that they are allowing for RINs to be generated indefinitely right now because we don't know when they're going to resolve this for fossil-based hydrogen. Thank you, Your Honor.
Mr. Purpuro.
May it please the court, Alex Purpuro again for respondents. This court should deny Saber's petition. Saber fails to timely challenge EPA's regulatory inclusion of certain fuels in the biomass-based diesel category. And further, EPA's interpretation of those different fuels is reasonable and is within the statutory text, and its implementation of that category is reasonable. To begin with the reopening question, as Your Honor pointed out, Saber's challenging EPA's definition of pathways more than a decade past when EPA established those definitions. It doesn't point to anything in the record indicating that EPA reopened these categories. As this court stated in Growth Energy in 2021, a general invitation for comments on a broad subject does not automatically reopen every aspect within that subject. And SABRE has not presented any valid basis for reopening any of these provisions, either through EPA's proposal or any other aspect of the rulemaking.
How is it that a fossil-based jet fuel qualifies as a bio-based diesel fuel?
So it's not a fossil-based jet fuel. So it's still produced from non-petroleum feedstocks. So but
it's a process question, right?
So I'm trying to understand the arguments presented today, but the 2013 pathway allows for renewable jet fuel produced from lipids, from animal fats, from oils, so different types of renewable resources that can be converted in the same process as renewable diesel. So you put those, I'm probably exceeding the limits of my scientific knowledge here, but you put those things into a processor and out comes several chains of hydrocarbons. So the broader grouping of those hydrocarbons is renewable diesel, which is kind of the more inclusive set of those molecules, but you can take a subset from that process of those molecules to create number one diesel or jet fuel. And that is still produced from non-petroleum feedstock. So it's not coming from a non-renewable resource and still complies with the statutory definition. Similarly,
so what do you understand her to be referring to when she makes that point? Something to do with the processing method?
So she was referring to a cornstarch ethanol to jet fuel pathway, which would still be a renewable resource. I believe that's the item she raised, but the one that wasn't really addressed in the briefing. I don't know that any particular aspect of that was argued by SABRE other than maybe a passing reference. My understanding of the cornstarch ethanol to jet fuel pathway is right now there's a facility by facility approval process for creating that type of jet fuel from ethanol. It would still meet the statutory definition because the statutory definition isn't limited to animal fats or oils, as my friend on the other side suggested, but rather non-petroleum renewable feedstocks, which corn ethanol and cornstarch would still be. So to that extent, it would still satisfy the statutory definition, but to the extent they're challenging that particular pathway, I mean, they don't really raise that in the briefing or explain, you know, how they can raise that type of challenge in this case. But to go to the broader point, I mean, the biomass-based diesel definition, contrary to SABRE's contention otherwise, is not limited to monoalkyl ester biodiesel. It's defined as a diesel fuel substitute produced from non-petroleum resources, which renewable diesel and jet fuel fall within. It's not saying a particular product, it's saying it's a produced product that substitutes for petroleum diesel.
So on the reopener point, I guess perhaps EPA gets closest when it requests comment on whether it should adjust the equivalence value for wind generation for renewable diesel if it adopted an energy content-based definition of when a renewable diesel is, quote, produced from renewable biomass. So I guess there's a plausible argument that EPA's decision not to make that adjustment was arbitrary or reopened this.
So we don't argue, we don't make a reopener argument with respect to the equivalence value. We acknowledge that EPA proposed a definition of produced from renewable biomass and explained a number of changes that could result from that. And in the final rule explain why we didn't finalize that action, but it wasn't a decision not to take action on it. It was, as EPA explained, to give itself more time to consider comments and to consider the array of approaches it could take in finalizing that definition. So EPA hasn't acted here to say we're not going to revise this or modify it, but there are different approaches that EPA could take to revising the equivalent value based on the definition it lands on for produced from renewable biomass. So we believe that decision was ultimately reasonable on the record, that EPA, as this court has recognized, can control its control the timing of its rulemaking and need not resolve every single aspect of an issue that's before it in every rulemaking. I mean, as this court's likely aware, this was a very large rule with many regulatory changes and many aspects. And as obligated parties point out, certain aspects were late. So EPA accomplished what it could with this rulemaking, but certain matters such as this were relegated for future rulemaking.
I'm sorry, you're saying the equivalence value issue was not reopened?
Was reopened.
Or was?
We're acknowledging it. We're not making an argument that it was not reopened.
Okay.
You're right. This has been a long morning. So help me out. The non-renewable portion of the co-processed fuel that's referenced at JA 252, that is, I think, part of what Ms. Franco is objecting to. Can you explain how this is a bio-based diesel if it has a non-renewable portion?
So EPA defined. This is what comes from the statutory definition is the term co-processed. So co-processed fuel does not qualify as biomass-based diesel. And in 2010, EPA created a regulatory definition for the term co-process, wherein it determined that means if renewable product and petroleum product are processed at the same time in the same unit. So that would not qualify for biomass-based diesel, but it explained in the regulatory text in defining that, well, not in the rulemaking, in the preamble of that rulemaking, that the fact that a non-renewable minor element is used to make that fuel does not make it non-renewable or co-processed within the meaning of the statute. And as we point out in our brief, and as EPA pointed out in the 2010 rulemaking, finding that in addition of a petroleum element like hydrogen or like methanol in biodiesel would also eliminate volumes of biodiesel from being qualified under biomass-based diesel. So it's not a issue unique to renewable diesel here.
Thank
There are
you.
no further questions. Thank you, Your Honors.
And Ms. Franco, you have a short period of time for rebuttal.
Yes, thank you, Your Honor. I'd just like to make a couple of points. On the reopener, EPA did ask for comment on whether or not it should continue to use the single percentage standards that it had used pre-2022. And so we don't, we think that certainly was an issue that they could have addressed if they could create subcategories, which is something that folks have raised in the past. So it was certainly reasonably anticipated. I think you kind of got to the issue we were trying to make on the hydrogen part of the renewable diesel and jet fuel, whereas EPA, the equivalence value is counting the energy coming from fossil-based hydrogen, where it discounted that for a biodiesel and for ethanol. They did not do that for renewable diesel, and they have decided to just, in our opinion, confirmed that they will continue to do the equivalence value based on energy. So we don't think all of these other regulations that they're looking at changes that in any event. Again, it's been 3 years already, and we're still waiting. And then just...
And do your clients have standing to challenge the conversion factor? Because as I read it, the conversion factor actually benefits you by increasing incentives to use fuels and granted in the broader category, but in the category that includes your clients' fuels.
Yeah, that we disagree with. So all EPA was trying to do with the conversion factor was better reflect the portion of biodiesel being used and the portion of renewable diesel being used, which has the higher equivalence value. So it was not increasing the gallons used, right?
But if we vacated the conversion factor, that would harm the biodiesel producers that you represent because it would reduce the volume requirement for the effectively reduce the volume requirement for the biomass-based diesel category in which your clients compete, right?
We don't believe that's true. The volume requirement is still there. What we think the concern with the conversion factor, where we think we have standing, is that there will continue to be a competitive advantage to renewable diesel because of the higher equivalence value. So if you require more RINs through this higher conversion factor, then there's more incentive to get renewable diesel. So there's no benefit to the biodiesel industry. Whereas if you're doing it at least off of
the benefit to the overall category.
Right, but that doesn't benefit the biodiesel. Correct. There's no evidence that it would flow to us. Whereas if we're at least all looking for 1.5, right, we are at least more on a level playing field. And so for us, it's a competitor standing issue.
Except that the RIN conversion, you would benefit from it even, well, I'll have to think that through. I won't belabor it right now. All right.
Well, thank you. If there's no further questions, thank you, Your Honor.
Now we're proceeding to part 3. Counsel for Neste?
Yes, Your Honor. May it please the court, Jeremy Byland on behalf of Neste. Neste is a renewable fuel producer that produces and imports hundreds of millions of gallons of fuel into the United States every year. And our issues are different than any of the issues you've heard today, and I just have 2 points. First, to explain why the EPA did not engage in reasoned decision-making with their unexplained changes to the record-keeping provision. And second, to explain why EPA failed similarly in their RIN generation requirement changes, where they moved from a flexible regime to a rigid prohibition. Before I do that, though, I wanted to just briefly explain how the industry works to make renewable fuel from separated food waste. So used cooking oil is probably the most prominent example of separated food waste, and we're going to call it feedstock. Producers buy this feedstock from aggregators. Aggregators are usually small companies that go around and collect that feedstock from restaurants. They then commingle it in their trucks and commingle it in their storage tanks. Producers will then buy batches of that feedstock and receive certifications from the aggregators that that's renewable biomass. And the producers will then produce renewable fuel and can generate RINs for all fuel produced for use in the United States. And before 2023, the producers had the flexibility to retire those RINs voluntarily if that fuel wasn't ultimately used in the United States. The EPA has unsettled this well-oiled system without giving reasoned explanation or adequate explanation. And unsurprisingly, there were a lot of comments challenging the EPA's approach, including Neste, who provided reasonable alternatives on both of these bases, and EPA has failed to meaningfully engage those alternatives.
So you're saying that before 2023, producers could retire RINs voluntarily if the fuel wasn't used in the United States, but did not view themselves as required to do so?
So they wouldn't have been violation of the law at production of that RIN that was ultimately not used in the United States. What would have violated the laws?
What if they didn't? What if they then sold the RIN?
If they sold the RIN, that would have been a prohibited act. But generating the RIN wouldn't have been a prohibited act. So in 2023, what happened is they made generating the RIN a prohibited act, which creates kind of hangs this sort of Damocles over the producers. The producers cannot predict with perfect clarity where that fuel is ultimately going to be used. So making that retroactively a violation of at generation causes a huge problem for the producers. And
so before the set rule, Neste would generate RINs on all its renewable fuel, and then eventually, if the fuel ended up outside the United States, it would retire those RINs and somehow account for that.
Your Honor, so it would segregate fuel produced for use in the United States according to the regulations. And then if that fuel did not end up being used in the United States, they would voluntarily retire the RINs. But there is a segregation requirement, so it's not the case that you could just produce all your fuel, generate RINs. There's other requirements that make it more tailored than that. But yes, Your Honor, to your other question, they could voluntarily retire that RIN, and at that time would not have been violating any prohibition. Whereas after the 2023 rule, just generating the RIN is a violation that can cause penalties if that fuel is later not used in the United States, which.
And how does EPA even know you've generated a RIN though if you never
So there's
sell it or it's never retired by anyone for compliance purposes?
So my understanding is that you retire it and you note that in the spreadsheet, and then there's a reporting process with EPA. So when you transfer the RINs, obviously that will be recorded. If you generate a RIN and retire it, that's noted in your report to the EPA.
So your view is that under the new rule, if you continue your old practice of for all fuel that you believe is going to be used in the United States, you generate RINs, turns out some of that fuel is circumstances change and it's exported, that if it went to EPA and voluntarily retired those RINs, that you would be subject to some kind of liability under the statute?
Yes. Because they made the generation of that RIN it's invalid to generate a RIN for fuel that's not ultimately used in the United States. And if you follow that through, generating an invalid RIN is a prohibited act with penalties. So it creates this strict liability regime that's just unworkable.
And how does this relate to designated as RFS FRRF?
I think that's just a designation of the RIN and to be used within this renewable fuel set. And I just wanted to talk about the record keeping provision, if I could. Oh, sorry, go ahead, Your Honor.
So you don't have to generate a RIN when you produce. So I thought RINs are well, do you? You don't have to generate it when you.
So EPA says in their brief that we could produce them at some other time, but it doesn't ever solve the problem. Because like we never have, after the fuel leaves our possession, we have no control at the end of where it's used.
If you sell it within the United States and have no reason to believe that it's not going to be for use in the United States, isn't then the burden on the next entity? Like, I mean, I don't know how many hands it passes through, but if you sell to a blender that is, going to use it in the United States, you're fine. If you sell to a blender you believe is going to use it for the United States and the blender ends up sending it out, then isn't it on the blender to comply?
Not under the text of the regulation. Under the text of the regulation, we're still liable retroactively for producing that RIN. And that's the problem. The prior system had that flexibility. We're not asking for RINs to be used or sold for fuel not used in the United States, but there's a strict liability, and it's a real problem. I wanted just to talk, unless you have any other questions about RIN generation, briefly about the record keeping. The problem is the EPA hasn't adequately explained why they made the changes in the record keeping provision. I wanted to point you to the record at the joint appendix at 554, where Neste proposed a reasonable alternative of an enhanced verification process that would take care of the EPA's fraud concerns. And then the EPA just simply didn't respond to that. If you look at the joint appendix at 1902, the EPA said that the commenters didn't provide any ideas about a verification, and that's not true. And so I think that shows that the EPA didn't evaluate and give reasonable explanations for why they were rejecting our reasonable alternatives. And then there are other reasons for the changes that it's always been required, which we show in our reply at 2-7 why it wasn't, and also that there's widespread fraud. And again, even if they can point to a couple instances of fraud, they didn't explain why our reasonable justification was unworkable and why they rejected it.
Why was it infeasible to do the record keeping requirements as they suggested?
So it's infeasible for the producer to say how much. So we buy our feedstock from an aggregator.
Mm-hmm.
The aggregator goes around and collects it from restaurants. So we don't know how much from each individual restaurant made it into the batch that we bought from the aggregator. It's just like if you went.
You're just saying if it's from the aggregator.
Right.
But what about from original sources?
So we wouldn't know how much from the original source made it into our batch. It's like if you went to a gas station and you recorded all the gas stations you went to and the amount, you wouldn't know which fuel track your gas came from.
Sure.
I guess if you're asking.
But I guess that's what I'm saying. It assumes that you're always buying from an aggregator.
That's true. When we're buying from an original source, we're not saying that we wouldn't report that.
But there's also EPA provided for this alternative compliance where, I mean, an aggregators are going to have to step up and themselves do record keeping if they want to stay in business under this rule.
Your Honor, so we commented as to why that's an unworkable alternative path, and that's our reasonable alternative. Our reasonable alternative was an enhanced verification process that put the cost on the producer, but still made the aggregator make its records available. And that's at 554, Joy Appendix 554. And they didn't explain why
they said in their response that no one talked about enhanced verification, and that's just not true. And the reason it's unworkable, just to close the loop on that, is that these aggregators are often small companies that just can't afford the overhead of registering with the EPA in this.
Can the producers?
We have
Afford it?
volunteered that, yeah,
Well,
volunteered.
if they can afford it, can't they work that out by contract? Isn't that sort of gonna happen if?
Well, the problem, if you look at the alternative pathway, the aggregator has to register with the EPA and have its own, basically their own auditing program. And they're just not willing to do that.
But all I'm saying is that it could effectively, the cost could be on the producers if they just pay a little bit more.
But the aggregators, especially
Or
foreign
discount the cost of their product.
possibly, but the problem is the foreign aggregators, and we're a foreign importer, so we're not a domestic producer. The foreign aggregators don't have any motivation to, you have to subject themselves under that record pathway to the jurisdiction of the EPA, and the foreign aggregators have no incentive to do so. I think, Neste is a good player in the market. We don't want fraud. Fraud hurts us just like it hurts the US fuel supply. But the point is, we came up with a workable solution that would take the burden off the aggregator that EPA didn't engage.
Mm-hmm. And I mean, the foreign aggregators would still have incentive to continue to sell to Neste. Right. So, I mean, they would have, you said they wouldn't have the incentive to do this.
They have the incentive to sell under our alternative they do, under
Not under EPA's rule.
not under their alternative path, which requires those foreign aggregators to subject themselves to the jurisdiction of the EPA. I don't think we haven't seen in the market aggregators willing to do that. But I think it just highlights, I mean, there's a lot of maybe possible ways you can do it, but it highlights the problem that they didn't really engage with our proffered alternative and explain why it was unworkable to reduce fraud. So with that, I hope I could just have a minute for rebuttal. We have nothing further.
And Mr. Papuro?
Good morning again, Your Honors. May it please the court, Alex Papuro, again for the respondents. We ask that this court deny Neste's petition. EPA recently implemented its longstanding record-keeping regulations and fully explained why it's requiring RIN generators who produce renewable fuel from food waste to keep location information regarding the fuel it produces. And further, the RIN generation regulations don't impose substantive changes to the program as Neste suggests. Beginning with the record-keeping requirements, I'll respond largely to their contention that EPA didn't fully explain the reason for this requirement in the record. That's simply not the case. EPA provided over 20 pages of response to comments explaining exactly why these regulatory provisions are necessary. It is impossible to tell from a finished fuel exactly where the feedstocks came from or what feedstocks the producer is using. So EPA has record-keeping requirements that it imposes for parties to comply with those requirements and therefore maintain the ability to demonstrate that the fuel they're producing that is used in the United States is produced from renewable biomass. One case I'd like to point this court to that came out after we submitted our brief is the Coalition for Renewable Natural Gas versus EPA case. That's 108 Federal 4th 846 from this court this year. That was a challenge to other compliance provisions that were actually finalized in the same rulemaking at issue today. That court upheld all the requirements, noting that EPA has not just the authority, but the obligation to ensure that fraud does not occur in the program, because fraud means that fuel being used for compliance is not coming from a renewable source. The court there held that the regulations were reasonable, that EPA was not required to demonstrate specific instances of fraud. In fact, with that program, EPA had acknowledged that fraud had not occurred, or it was not aware of fraud.
Yeah, I don't think Neste is challenging the interest in avoiding fraud. They're making a point that they did not previously track RINs at the time of, or they did not previously think that they face liability at the time of producing renewable fuel with a RIN, so long as any renewable fuel that ultimately wasn't destined for use in the United States did not, the RIN wasn't separated and used for compliance or marketed. And do you have any response to his concern that under the current rule, it creates a liability that the prior rule did not make clear?
So I was referring to the record keeping provisions, but I'm happy
I'm
to address.
sorry, I'm getting, yeah, been a long morning, but
No,
I
understand.
Yeah, but even then.
isn't the record keeping about the tracking where the oil comes from and therefore making sure that it is bona fide, right? It's a separate issue. So I have questions about both of those. But on his point about RIN generation and whether generating a RIN on fuel that was perhaps originally thought to be destined for use in the United States and that doesn't end up being. What's your response to whether there's some jeopardy that is newly crystallized for them that didn't exist under the prior rule?
We don't agree with that, Your Honor. The prior regulatory scheme was consistent with the statutory text that renewable fuel that is not used in the United States does not qualify within the program. And EPA has in the past, there's an example cited in our brief, invalidated RINs that did not get used in the United States.
And I think they're saying they're perfectly happy to invalidate any RINs for fuel that isn't used, that isn't in fact in the end used in the United States, but there's some play between what they think is going to be used in the United States and what ultimately does get used in the United States. So if they make their best good faith effort and they say, 1 million gallons, and then at the end of the day, it's 900,000 gallons, they understand it's their obligation to voluntarily retire the 100,000 gallons that they overestimated would be used in the United States. But their position is that that's not good enough for the EPA. Is that right, that that's not good enough for the EPA?
I think they're reading in more than what EPA explained on the record here. So EPA explained that the regulations provide that a party who generates a RIN should have a plan that that fuel is used in the United States. They should not be generating RINs, regardless of whether they know or if they don't have a plan. That's kind of what the regulations get to. And EPA explains in the response to comments that in situations where they've made a good faith effort to generate RINs on fuel that they believe is going to be used in the United States, and there's an issue there, EPA has a remedial action process by which a party can engage with EPA to address that issue. It doesn't necessarily result in instant liability, as my friend on the other side suggested.
Right,
and EPA also explained there's other practices a party can engage in. So it's a long morning for me too, but the RFFR, the labeling requirements that they refer to, I think we explained in our brief, do not compel them to create or generate a RIN at the time that they produce fuel. They must do labeling to ensure that it's properly documented where this fuel is coming from, but ultimately they have discretion in when to generate the RIN. So if there's some concern that they can't perfectly predict or are unsure when to generate the RIN, then there are options available. One cited in the record in the response to comments is they can have the US-based producer generate the RIN rather than the foreign producer who hasn't let the fuel go yet generate the RIN. So there are options and flexibilities provided by the program.
And back to the record keeping that you were addressing, and before I took you back to the generation for use. So what about this question of an aggregator that is overseas and how challenging it would be for, to assume that they're going to be willing to use this alternative compliance that EPA has designed? I mean, I gather there's two issues here. One is that the aggregators, their business model is that they know where to find the used cooking fuel or whatever, and that's their whole business model. If they start reporting where they find it, then they get cut out of the loop. And so EPA's response to that is, okay, well, you can confidentially report it to EPA. But if they're foreign, they don't particularly want to be dealing with the EPA, plus they're not sophisticated. They don't want to have all the paperwork of having to deal with that.
So I have two responses to that. Well, I guess I'll start with some background and then two responses, which is EPA created this option, which is not a requirement, to comply with these record keeping requirements in response to this exact concern that aggregators would be unwilling to share this information. And EPA created this option because it still needs assurance that the renewable fuel used to comply with the program is actually coming from a renewable source. Without location information further down from the aggregator, it's impossible to tell that the fuel the producer is getting is actually renewable qualifying fuel, such as a used cooking oil or something else that's not qualifying under the program, because it's not distinguishable at the point once you create the fuel. So EPA has created that in response to the concerns regarding burden. I mean, there are the program, EPA's obligation is to ensure that fuel produced is from a qualifying feedstock. And if their concern is they don't want to comply with EPA because they're not interested in the program, I mean, there's a concern there that what other steps are they taking to comply and keep records. But ultimately, EPA's first and foremost duty is to ensure that the fuel used is qualifying. The similar issue came up in the Coalition for Renewable Natural Gas case, that there was a concern that certain producers would not participate because the program requirements were too burdensome. But ultimately, this is not a compulsory program. It's designed to create incentives for the production of renewable fuel through the benefits that the program offers, through RIN prices, through the compelled sale of biofuels. So EPA believes the program is sufficiently incentivized enough to continue the sale of these fuels. But to the extent an aggregator decides, I don't want to participate in this program anymore, it's too costly, that's their decision. So I think EPA's regulations are reasonable in light of that context. The court has no further questions. I thank you for your time this morning.
Well,
Thank
just
you. I'm
a
sorry.
quick follow-up.
Yes, Your Honor.
There was a comment about whether or not they adequately publicly commented in this regard, providing you alternatives and timely commented. So I just wanted to know if you had any comments regarding that.
I'll note that in neither their opening brief nor their reply brief did they point to an alternative that EPA didn't adequately respond to, despite us raising that. So I know they mentioned something in their comment. I'd have to look at the response to comments to see the exact response to that alternative. But EPA has 20 pages of response to comment. I believe it's Joint Appendix 1885 to 1915, I believe, where EPA fully addresses every alternative and option and tweak and counter proposal that party suggested regarding this alternative compliance provision. So we believe EPA has reasonably complied with its responsive duties here.
Thank you.
Thank you, Your Honors.
Your Honors, a couple of points. We raised in our opening brief at pages 21 to 22, the fact that EPA did not respond to our reasonable alternative. I'll point you to JA 554, where Neste in its comment letter introduced an enhanced verification process whereby the aggregators would have to open their books and provide the location and the amount from their original sources, but that burden would be put on the producers and not on the aggregators. And then I will point you to JA 1902, where EPA says commenters do not suggest any type of verification activity. We specifically raised it. EPA specifically ignored it. We raised it in our opening brief. One other point on the RIN generation point, they point to a remedial action pathway. If you go look at the website, that actually doesn't absolve you of guilt. You can still be penalized. It says you can still be assessed a penalty. All it is a self-reporting program. So with that, we'd ask that you vacate these requirements. Thank you.
Thank you. Thanks to all counsel. Thank you for your patience and with us and with the time. Case is submitted.